the one-man committee was appointed by an order, by a judgment passed by the Honorable Division Bench of this court, presided over by the Honorable the Chief Justice, was passed on December 23, 2015 by the 2015 by an Honorable Division Bench of this court, presided over by the and the committee has been authorized to deal with matters relating to the MPS. This is also MPS.
No, this is
VIVJ. This is the subject matter of another
matters belonging to several companies, including VIBGYOR.
Well, VIVJ has not been made a party.
But
Nor SEBI has been made a party.
SEBI is acting on behalf of the committee. SEBI need not be a party.
This court, the matter is released due to lack of determination. Paragraph, the matter be placed before the Honorable Bench having determination.
But let it be Honorable Division Bench taking up Ponzi matters. That
I have said Honorable Division Bench having determination.
Grateful.
But one thing, where Lordship has been kind enough to mention the particulars of the plot, Lordship will kindly mention the name of Mouja is Gopalpur. Mouja is there.
It's Mouja Gopalpur?
Yes.
LR Khotian number? Mouja Gopalpur.
Grateful to Lordship.
Grateful.
Next.
Deeply obliged.
Item 2. None appears for the applicant petitioner. Paragraph, let the matter appear under the same heading in the monthly list of February 2024. Item 3.
Item 3, I wish to appear on behalf of the petitioner.
I am for the respondent. So I am in this review application.
Contempt.
Contempt and also the review.
There's a review also.
Yes, Lordship. In this review application, I am for the respondent. There is a direction for the file a revision oppositions and also the reply. So revision opposition is ready for, but it not affirm, Lordship, due to the illness of the.
It is your review application.
My lord, this is the time for exception, file exception. He took time previously, my lord, to time.
Yes, Lordship.
Exception, my lord. Today, he, my lord, paid for time.
Lordship, respondent, he is very illness and he is hospitalized, Lordship. So due to
senior, my lord, told me, my lord,
due to some difficulties.
Yes, he and for my lord.
On prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19th February.
Yes, Lordship. Good.
My lord, I tender my apology, my lord. I was told that this matter is appearing as item number 3. I was appearing in item number 2, my lord. My lord, I was under misconception, that's why I could not appear. I was present in the court, my lord. My lord, but it is a contempt application, my lord.
Not today. Is service complete?
Service completed, my lord.
I'll just make it not to.
My lord.
Item number 2, not today.
I tender my apology, my lord.
Yes. Item 5. Yesterday.
Yes, my lord. My lord, I will to get to produce all the original file, my lord. I am calm with the original file, my lord.
Mr. Pan, you wanted to
And my
file
lord,
an
I have
affidavit in
shown-
opposition.
I have shown, my lord.
Just I'd like to show your lordship two documents before your lordship. If your lordship finds that payment has been made, I will be out of court. First, my point is this, my lord, I have gone through the record. Mr. Dev was kind enough to allow me to go through the record. I did not find any notice that was served under section 7 of the Act of 19. No such notice was I find.
Notice
Moreover, my lord,
এটা notice
your lordship kindly turn to their opposition.
একটু দেখে নাও notice একটু দেখে নাও notice টা
But this time, this has been served. Now they are showing. Now kindly, my lord, see, my lord.
my lord, previously, my lord, I have
Yes.
bring all the files, my lord. I have shown my
I
landed
am relying on this. I am relying on this. Very good.
and my lord,
But
money
just a minute. Just
money receipt was there, my lord.
kindly see, my lord. My lord, should I hand over my copy
এটা
to
কত?
the lordship
80%?
of the affidavit in opposition?
80%. এটা 80%.
Add করে দিই, sir.
এ দুটো দেখে নাও অরিজিনাল দুটো তো দেখেছো 80% and 20%.
Hmm?
80% and 20% তো তোমাকে দেখে
দাদা কোনটা?
দেখো এটা 80% ওসমান গনি
হুম।
আর এটা হচ্ছে 20%.
হুম?
আগের বার দেখিয়ে দিলাম 80% and 20%, that is 100%.
Kindly see. The original din, original din. Lord,
My lord, your lordship will see the original 80% and 20%.
The writ petition was disposed of.
Yes, my lord. Directing my lord us.
একবার দেখি ওটা দেখি একবার দেখি ওটা এই জয়ন্ত একবার দাও না
না,
কিছু
না না তুমি তোমাকে দেখার জন্য তো যাবে অদারিতা পাবো
ফোনটা গেল কোথায়
তোমাদের না আমাদের না আজকে তোমাদের না কন্ট্যাক্ট
মিলনটা আমার ছেলে ডিপার্টমেন্টাল এনগেজমেন্ট যাক নামটা দিয়ে দিই দেখি একটুখানি একটা কাগজ দেবেন
দাঁড়াও দাঁড়াও একটু
There's a declaration under 7A.
Yes, my lord, everything is there, my lord. My learned friend took the point that he want to see the original of the 80% and 20%, my lord. I have shown, and the notice, my lord, I have come with the notice, my lord. And I also, my lord.
Mr. Pan, do you want to go through these documents and come back?
But kindly just for my satisfaction, because I have talked to my client twice. They say they cannot remember, but they have received the payment once, but they do not know whether the award, a final award or
The
not.
document says otherwise.
But kindly have a look at the document. This is not the award sheet, this is the voucher. Now kindly have a look at
Mr.
the.
Where is the 7A award?
This is not the 7A award. Under any stretch of imagination.
My lord, award is also there, my lord. You want to see the original voucher, my lord, original voucher. I have, my lord.
No, no, all the original
Yes,
documents.
my lord,
were
all the
copied.
original document. See this. My lord, in any time, my lord, my lord, I showed everything to my learned friend, my lord. On that day, my lord, he wanted to see the notice, my lord. I come with all the papers, my lord, with notice, as because on that day,
Show me the 7A.
my lord, everything is there, my lord. He can show, my lord.
Please show me the 7A award, declaration of awards under 7A.
এই তো নাও দেখো
জজ সাহেব বলছেন জজ সাহেবকে দেখানোর
জজ সাহেবকে দেখানোর জন্য
It should
my
be
lord,
prior to 31st
my lord,
March.
your lordship will see this. নাও নাও তোমাকে ওগুলো জেরক্স করে দিয়েছি আজকে একটা এগুলো সব জেরক্স করে তোমার জন্য
এক মিনিট দাঁড়া দাদা, এক মিনিট।
এর মধ্যে আবার কোনো করা আছে এগুলো নোটিস তো ব্যাস বাবা আমরা কি ফাঁকি দেব তোমাকে সব
This is the payment voucher,
yes my lord I am everything is there my lord
but I want to see the declaration of award.
declaration of award is also there my lord if your lordship will see
7A declaration, where is it?
Yes,
At
ma'am.
page?
এই 7 এর ডিক্লারেশনটা বের করো তো
আমি জানি না, সেটা ওরা বার করতে পারবে তো।
হ্যাঁ ওদের
Where is the
করবে।
7A? এটা বলুন, বার করুন ওরা।
এই তোমার ওই যে অ্যাডিশনাল কোথায় এই তুমি আসতে পারছো না এই দেখাতে পারছো না 7 এর ডিক্লারেশনটা
These are all payment vouchers.
And that is their affidavit case, that 80% payment was made. Based on that, my lord, your lordship was kind enough to dispose of the matter.
I filed the review only for that reason, my lord. In that, my lord, paragraph, there is a specific.
Mr. Dey,
No, my lord,
not to
only
shout
for
like
that.
that. I am not alleging against
Mr.
you.
Dey, please show me just one
Yes.
document, 7A declaration.
I
of
want
award.
to help you, that so that I can also satisfy myself, so that I can satisfy my client as well. You kindly.
My lord,
Please
every
make us
day in his chamber, my lord, I personally went to his chamber and shows everything, my lord. On that day, he requests me only to see the notice, my lord. I come with the notice, my lord. Today he is taking another plea, my lord.
Mr.
That
Dey,
is,
I
my lord,
think
everything,
that is irrelevant.
my lord, I filed this, my lord. He can see that and come.
Mr. Dey, I've seen this. I do not find the 7A declaration in this. Please show me the 7A declaration. Otherwise, there is nothing wrong with the order. You have to show that the 7A declaration was prior to 31st March 1995.
My lord, I must file another
Please-
report, my lord.
Please come to this.
My lord, today, my lord,
paragraph
it
10
is
of the
not
order.
possible for me, my lord. Every day, my lord, if my learned friend, being an advocate, my lord, he wants everything that is today, my lord, I can't. My
Mr.
lord,
Dey,
I must file.
since
No, my
you
lord, that
have
is,
asked the review.
we are advocate, my lord. I have some, my lord,
But
what?
enough is enough. Then I
Enough.
must say something. But enough is enough.
Something.
But what wrong I have submitted before your lordship, my lord?
There is no question of all that
Yes.
at all.
Yes, my lord, I can
Since
show.
it is your
I can, my lord, he will come with all.
Stop.
I must show, my lord, today, my lord, I am not
It is
ready
your-
as because, my lord, he told me that all the things was there, my lord. So, my lord,
I
I may
have
not.
not said that
go
all
to-
the things
Mr.
are
Dey,
there.
the application is between you and the court, not between you and Mr.
Yes.
Pan.
No, my lord, only court, my lord. For that reason, my lord, I must show that.
It is your review application. You have to substantiate your application.
Yes, my lord, I must.
And paragraph 10 is important of the judgment under review. Paragraph 10
Only for that reason, my lord, he wanted to see those things, my lord.
Mr. Dey,
We
I'm
have
not
shown everything.
interested in what
My
you
lord,
wanted
today,
to
my
see.
lord, your lordship said that you must show the 7A declaration. 7A declaration is here, my lord, but now, my lord, it is not possible for me, my lord.
Your documents, I do not find any 7A declaration. That should be prior to 31st March 1995. Otherwise, you have no case.
এই আরেকটা ইয়ে আছে না তুমি নিয়েছো দেখো না 7-8 কোথায় my lord I pray one
You want to come
another
back?
date
You want to come back? Yes. Very well. Report in the form of affidavit submitted on behalf of the applicant / alleged contemner is taken on record. Paragraph on prayer of the applicant / alleged contemner, the matter is the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th February.
yes ma'am
Paragraph 10 of the judgment yesterday. Twentieth February. Next. Seven.
Pursuant to your lordship directions, my lord, your lordship's order has been complied with, my lord. I have compliance report has already been filed.
My reply. And in nowhere in the affidavit of compliance, my lordship stated that they have complied the order of your lordship.
Well, this
So
is my
my
compliance
represent-
report.
What is your my lord? Order? Land was acquired for construction of a bridge. My lord, I
My lord,
I
in
did not
contempt
get any-
proceedings, my lord,
এই
he
তো
cannot
আমার-
reopen its case, your lordship
আমার-
kindly
আমার
see
বলতে দাও, তুমি বলবে তো।
page 28 of your lordship, my lord, your lordship's order passed in the contempt petition. The direction of your lordship is, my lord,
Disposing of the representation.
yes, but that has been disposed of.
What is my representation? My representation is claiming for compensation.
Where is the order?
38, page 38 of my affidavit of compliance, my lord. If he is aggrieved by my lord, he should file a fresh petition.
Yes.
লোক আমি বলেছিলাম তো
মৈত্র না মিত্র?
মিত্র
লিখতে পারতে দাও, লিখতে যেটা আমাদের
আজকে জানে আমাকে লিখছি সেসব
এখানে আরেকবার যে বলেছিল এক্সেপশন থেকে কোথায় সেটা কপি দেয়নি তো সেটা
Yes, they have come up with a fresh
Yes.
proposal. in
Yes.
the representation.
But that is the proposal. That is not the payment of compensation money.
Well,
My prayer is,
lordship has not directed
why
us to make any
why
payment.
I have filed the writ application. They did not disburse any compensation in favor of the petitioner. But that is why I made a representation before the authority. The authority did not consider the same. So finding no other alternative, I have filed the writ application. Your lordship was pleased to direct to dispose of the representation. What representation? The representation I paid for compensation.
Yes, they have dealt with your representation and they have said that the earlier proceeding has lapsed.
Yes.
So they propose to initiate a fresh proceeding. And that is under the 2013 and that is to your benefit, sir. Why are you aggrieved?
Well, I agree, Lord, as I did not get any
The
compensation.
land
That
is
is
utilized. They say that the acquisition proceeding has lapsed. So they propose to initiate a fresh acquisition proceeding, which will definitely be in your favor. It's the 2013 Act. Now there is no other statute.
no.
If they initiate a fresh proceeding, it has to be under the 2013 Act.
Lordship.
Yes. So why are you aggrieved by this? And your representation has been disposed of with certain proposals.
In that way, Lordship, kindly make that observation so that I can able to
What
make a
observation?
fresh application.
Approach the authority. It is their observation. Yes. And this will inure to your benefit.
Lordship, grateful.
Third learned counsel for the parties. It appears that the order under that the alleged contender has disposed of the representation submitted by the petitioners in compliance with the order under contempt and in disposing of the same, has proposed to initiate a fresh acquisition process In terms of the present provisions of law. Paragraph, the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being being CPN such and such is disposed of. Paragraph, there shall however be no orders to cost as is referred.
Extremely.
I'm good. Well, I just satisfied.
Next.
Item 8.
I'm for the petition.
Yes.
And your lordship's order dated 1st of December 2020.
Is it forwarded by the BLNRO?
Yes.
It has been
1
forwarded.
month ago, madam.
And then
1 month
after
ago.
that,
Now, after that, Manoj, there was a question of physical inspection. I was trying to convince my learned friend more than my lord that if 1 month's time is given, my lord, I kindly fix a date after a month, my lord.
Inspection has been made thrice.
No, there is a letter of 5th of January, my lord. This is an internal letter, but it seems I am not going into that, my lord. My humble prayer is, my lord, a month's time may be given, my lord, and hopefully, my lord, we will all smile thereafter. It's not that they are not working at all.
snatching of the petitioner's smile and then you
No, my lord,
time has been granted.
my lord, may I only indicate one thing? No, because the divisional person was not cooperating. Now, after the order of my lord, Office of Block Land and Land Reforms Officer, my lord, has cooperated. Now, my lord, it's not only because my learned friend has waited for long, my lord. I don't want.
ID rule be issued.
My lord,
Have to pass this out.
may I only pray for this? May I only no. My lord can definitely, well, because compliance is what we wanted. Kindly give us at least, my lord, a fortnight's time, my lord. Let us come back. If not, my lord can pass a rule at any point. It's a question of, my lord.
After conducting of physical, they have asked for documents. Thereafter, it has been
No,
forwarded.
no.
Now
We are processing it. It's not. There's a letter of 5th of January also.
Another month's time, ID rule be issued. No other. I'll give you another month's time. If it is not complied,
No, certainly, I will not appear and
its entirety by then, other I'll
Kindly
issue
record
rule
the
on the
order.
next occasion.
absolutely. Well, kindly.
Record.
Yes.
Kindly record the order.
Absolutely.
Paragraph, it is submitted on behalf of
Yeah.
the parties.
1 month's time. If not, we should. Yes,
That the
deeply obliged.
application submitted by the applicants / petitioners has been forwarded by the Block Land and Land Reforms Officer, Arambagh,
Initial order to kitchen.
to the Divisional Railway Manager, Eastern Railway, Howrah Division. Paragraph, learned counsel for the alleged contender seeks accommodation for a month to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 16th February. তার আগে করুন, as a last chance, the prayer is allowed.
Get deep.
তারপর let the matter appear under the same heading on 16th February. Paragraph, affidavit of compliance be submitted on the adjourned date, in default, rule be issued.
My lord.
Now it will be automatic.
No, my lord. I don't think that will be necessary, but my lord, deeply obliged, my lord.
Next matter.
Item 9. 9, my lord, I am for the petitioner, my lord. They have not complied with.
The file is not come. I'll just make it not today.
My lord,
file has not
tomorrow
come.
I have some difficulties, my lord. If your lordship kindly fix it day after tomorrow, my lord.
Yes, my lord, up to that, right? After that was withdrawn, and my lord, you appeal right now.
Copy then need to go.
So, but then,
No copy has been served upon me. And it is the last chance, the last occasion your lordship directed the last chance, my lord. Probably there is a section 5 application. They have not served any copy and no copy.
The file is not here. That's the difficulty.
Then day after tomorrow, tomorrow I have some difficulties, personal difficulties. It's doctor appointment for such reason.
File is there. Has the appeal been admitted? 16 January.
No, no, no. No copy has been served upon me. Am I to copy that?
Let it go out of list for the time being.
My lord, no section 5 application, nothing is there as
Wait for something to mention.
then
I'll grant you liberty to mention.
yes, my lord, because they have it is suffering from 2007, my lord, and
The appeal number is also not there.
yes, my lord. Filing number is open MAT 71.
71 of 2024.
Filing date 10th January.
It is submitted on behalf of the alleged contemner that the order under contempt has been carried in appeal by the alleged contemner
My lord, just
and registered as MAT number 71 of 2024.
my lord, just since they have not filed any section 5, my lord, as far and eye of law, there is no appeal. If your lordship kindly fixed it to in February, month of February, if they have filed any application, then your lordship kindly
Let the matter appear in the monthly list of February 2024.
yes, republish.
In view of the above. In view of the above, let the matter appear under the same heading in the monthly list of February 2024. Yes, next matter.
Item 10.
May it please your lordship, I am for the petitioner along with Mr. Pandit, my lord, Balram Pandit. My lord, petitioner is suffering from a smallpox. That is why he could not come, my lord. My lord, earlier time given a time to file exception, but exception is ready but not signed. Due to that, my lord, I failed to submit, my lord. Kindly add
Your
on
lordship,
for
your
2
lordship,
weeks, my lord.
subject to correction, your lordship, I am for the private respondent, your lordship, this contempt application should be dismissed, your lordship, with cost. Now, why I'm telling this, your lordship, order was passed by your lordship only. Your lordship, in the meantime, they have suppressed all the material facts, your lordship. Your lordship, I am the Rayat landowner, your lordship.
Application.
No, your lordship.
Then how you making this
Your
submission?
lordship,
Contempt
if your lordship
application.
kindly take this.
You are not the party to the contempt.
No, your
application.
lordship, that's why.
I cannot entertain your submission
No,
at
ma'am.
all. Please approach the authority.
Your lordship, but they have suppressed all the material facts in the contempt application, your lordship.
Approach the authority. You'll be given notice.
Give notice.
This is for removal of unauthorized.
Your lordship, already order has been passed by the assistant engineer, lordship.
That is 10-2.
No, your lordship, the final order, your lordship. If your lordship kindly takes the order once.
Assistant engineer cannot pass a final order.
The petitioner does not come under the Highways Act, your lordship.
That has already been decided, my lord.
They have suppressed all the material facts, your lordship. This was the notice of hearing, your lordship.
It says that the private respondent does not come under the purview of the Highways Act.
Yes, your
So
lordship.
what is your difficulty?
Your lordship,
It is in your favor.
yes, your lordship, in my favor, your lordship, but they have filed contempt application they have pleaded just, your lordship, that they are the Rayat landowner, your lordship, but I am the Rayat landowner, your lordship.
State make their submission in the contempt application. Why are you bothered?
My lord, definitive compliance, we have annexed
Yes, the petitioner
Ma'am.
will file an exception.
Exception, my lord.
26.
2 weeks, my lord.
Learned counsel for the applicants / petitioners seeks further accommodation to use an exception to the affidavit of compliance on the ground of illness of the petitioners. Paragraph, let the matter appear under the same heading on 20th February.
Ma'am, deeply pledged.
Next.
40 February.
Item 11, my lord, I am for the petitioner, my lord. Last occasion, my lord, the order of my lord is there. Yes, my lord, my learned senior friend has supplied me the copy, my lord. There is a direction for the direct purchase on the 13th of December, my lord. They have, by their letter, my lord, they had intimated the petitioner that they are starting the process for direct purchase, and they are seeking for the document. But my client received just now, my lord, 11th of January. They are
So it is substantially complied with in that case.
well, they are starting and
So let the contempt application be dismissed.
but if my lord,
My lord, he will get the money, my lord, at 9 lakhs and other, my lord, if you not will see.
I am not disputing that, but if my lord kindly take it next month. In the meantime, maybe the procedure may be completed, my lord. Otherwise, my lord,
That's not the purpose, isn't it?
My lord, he will
It's
get
being
the-
complied with.
Why?
It's substantial compliance. So let this be dropped. Why unnecessarily keep this matter in mind? Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, it appears that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no arrest to costs. Paragraph, as I said,
deeply obliged, my lord.
next.
Item 12. My lord, I am appearing on behalf of the petition. My lord, on the last occasion, the learned advocate appearing on behalf of the contemners had seek for accommodation to file the report of compliance.
Yes, who is appearing for the contemner? Compliance, today?
No, sir.
Whether I filed the affidavit of compliance or not, my lord.
Yes. Have you received a copy?
No, my lord.
I told it to be by that was what happened. Affidavit of compliance.
No, my lord, we have not received it.
One opinion, my lord, that is, we filed the
Received.
affidavit of compliance.
Sir, received.
There was an initial affidavit of compliance, Mr. Day, but after that,
Yes, ma'am.
that was not sufficient. After that, there is no compliance.
Then my lord, give me a word.
My lord, on the last occasion also, they prayed for an accommodation, my lord.
Accommodation to change. My lord.
My lord, the order was passed 1 year ago.
Mr. Day, please comply within the next date. Learned counsel for the alleged contemners seeks further accommodation to comply with the order under contempt. Paragraph, last chance. As a last chance, the matter is adjourned,
My lord, we filed the compliance.
but that was not sufficient, so a second compliance was called for.
My lord, that means.
That was
My
not
lord, if you
compliance
have
at all, in fact.
See my compliance.
Yes. Yes.
That is, my lord, first, my lord, that is the, after receiving para 3, my lord. After receiving WP number, Ato Ajit Kumar Maiki, this take a question, lord. Sign under request of the block land and land records officer Bhagalpur for demarcation of the government. According to the block land and land records officer, paragraph 4 minor with the case map. As per demarcation report, block land and land records officer, it is found that Ranit Samanta Singh, Gopal Pitta and others, Malad, Gopal Mati and the petitioner in the case are unauthorizedly enclose the government land and obstruct the place of the petitioner WP number. It is also noticed that Ajit Kumar Mati, petitioner of the 20 that is unauthorized encroaching the government land. Then, as per provision of West Bengal High Act, 10(1) notice was issued, my lord, and thereafter provision of 10(2), that is paragraph 7, my lord, and 8 accordingly is sufficient to by state, my lord, in the heart of the parties and any strong relevant document in report of BLRO, Bhagavanpur of the Ato, my lord. And as per order of the subdivision magistrate, paragraph 9, the undersigned paid for deployment of police forces and other things, my lord. And 10, my lord, Part Sri Gopal Matia, petitioner of WPA number Ato appeal before the district magistrate Purvo Medipur as per 10(4) of the West Bengal Highways Act, my lord. Then the hearing was taken by the district magistrate in presence of all interested parties, including petitioner and private. For instance, case, my lord, the parties. Here group individual of the available documents and record. The order of the SDM dated Ato is upheld by the district magistrate Purvo Medipur. The district magistrate Purvo Medipur also directed the BLRO of Bhagavanpur 1 to inquire the land of the coast to find out more encroachment if any and submit the report of the same. This is district magistrate Purvo Medipur also directed to SDM Agra to remove all the encroachment of the applicant. Paragraph 11. Pursuant of the order of the Honorable District Magistrate Purvo Medipur dated Ato and government demarcated the government land in question on Ato in presence of junior engineer of the director and interested parties and submitted the demarcation reports by memo number Ato. It is found that the 14 number encroaches are unauthorized encroached on government land in front of them. Accordingly, my lord, as per demarcation report of the concerned Ato, the undersigned issued another notice 10(1) against those parcels. Paragraph 13. Thereafter, as per provision of 10(2) of the West Bengal Highways Act, the undersigned paid before the subdivision magistrate not the 10(3). Then, accordingly to subdivision magistrate, paragraph 14 started the proceeding manner under of the West Bengal Ato. Thereafter, an eviction program has been fixed by the undersigned on 22nd November after partial completion of the said work. The undersigned came to know that an order has been passed by the Honorable Justice Melody Lord to pass the order that is in Ato. Himanshu Ato, the read and disposed of with regard to the petitioner prepare an appeal under section 10(4) of the Act against the order of the district magistrate character Ato being the respondent number 4 10 days from the date of Ato. Accordingly, as per appeal 10(4) of the West Bengal Highways Act, the order of the Honorable Court hearing was taken by the district magistrate in presence of all the interested parties. But the instant get passed an order to the individual of the available documents and records to the undersigned to take steps for removal of all the encroachment over the government land of PWD directorate from the plot number Ato to the number Ato. Accordingly, as per order dated Ato, the district magistrate government with the undersigned place for deployments of police forces to the officer in charge of the Purvo Medipur unauthorized. That on Ato, the Honorable Justice Your Lordship also passed an order of in WPA number 2168 of 23. Was pleased to direct the second respondent contact number 1 to reconsider the matter in the light of the Ato passed by the Ato after giving the petitioners have been liberty to place all documents in support of the claim, my lord.
Mr. De, this report is by the second contemner, whose name has been expunged. The first contemner was directed to comply with the order. And there is no compliance by the first contemner. Yes.
Yes, my lord.
On the basis of this, his name was expunged.
Only for that is my lord I have been.
So please come back with the report.
Yes, ma'am.
Learned counsel for the alleged contemner seeks further accommodation to submit the affidavit of compliance demonstrating compliance of the order under contempt. Paragraph, let the matter appear under the same heading on 20th February?
Yes.
Hello.
My lord. Opposition reply is complete, my lord, but affirmation has not done due to illness, my lord. and the petitioner
In this matter,
had 1%, my lord.
they wanted to
So
file
that
the
has not come, my
exception of this report.
Exception is not ready.
No,
You say that it has not been complied with.
no,
Already, my lord,
complied-
already complied today as far as
No,
the grievance
not
of the
complied with
petitioner
that.
is concerned.
They were part complied. So that I made a reply, my lord.
Learned counsel for the applicant petitioner seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 21st February.
My lord, I am for the contender.
For the petitioner, my lord.
My lord was pleased to direct the special land acquisition collector to decide to pass a reason order within 2 months. Accordingly, my lord, the order has been passed. My lord, joint inspection report was made, but petitioner was present. This is my my lord report, not in form of affidavit. I am handing over to my learned friend also. Intact for us. Reason order was passed. Tag, my lord, blue tag. Order dated 1st of September 2023.
Yes, it has been disposed of.
My lord, they have given a chance of hearing and then pass the order. But till then, my lord, I have to take instruction. People are can fix another date because just now I have got it.
You want to take instructions and
Lordship.
very. Affidavit of compliance submitted on behalf.
Sorry, my lord, kindly, this is not affidavit compliance. My lord, the reason order I have stated, humbly stated. Humbly stated, my lord, just now I received it, that is why I could not.
Please come back with an affidavit.
Lordship.
A learned counsel for the alleged contemner seeks to submit an affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 21st February.
21st.
Please
And
cover as
reason order already I handed over. My lord,
developed.
21st
Next.
February, next day.
My lord, I appear for the petitioner, my lord. In this,
I appear for the contempt laid by Mr.
But in this matter, my lord, there was a affidavit of compliance, my lord, by the respondents, my lord. We have filed a exception to the.
My lord, pursuant to the order, my lord, pursuant to the order, we have assessed the value of the, my lord, land and my lord, we want to submit the compensation to them, my lord.
My lord will kindly.
On
come
2
to-
occasions, we have asked them to provide their name, their bank details. They didn't. Thereafter, the matter appeared before your lordship. They asked for the my lord estimate done by the department that has been provided to him. Thereafter, we asked them to provide the my lord bank details of the petitioner so that we can send the money to them. But thereafter, I filed my lord the compliance report.
My lord will kindly.
And my learned friend, my lord, now they have perhaps they have come before your lordship that they are not satisfied with the amount of compensation given by the department, assessed by the department. My lord, this is a new cause of action. They should have filed another rate application challenging that, my lord. So far as the compliance is concerned, we have sufficiently complied with the order and filed the report. My lord.
My lord will take our exception, my lord. My lord, page 9, my lord, last line, my lord.
Page 9.
Page 9. Well, it is from page 6, my lord, it is their compliance report. From that only, my lord, page 9, running page 9, my lord.
Yes.
The LA case number is LA Roman 2 stroke 21A of 1980-81. Now, my lord will kindly come to my lord page 29. Page 29, my lord. In respect of the same case, my lord, in another matter, my lord, they have said that the entire LA case has lapsed. Page 29.
You are on merits of the order. You are on merits.
My lord,
In the contempt application, you are
He
aware
cannot.
that cannot be done.
my lord, few more lines, my lord. Thereafter, my lord, thereafter, my lord will kindly come to my lord, page 30B. Page 30B, my lord, this is another matter in relation to the same case, my lord. What they have done, my lord, they have given the market value. That will appear from page 30.
That's why I am telling my lords.
My lord, another round of litigation.
Another
This is
round
the
of
state-
litigation.
what
That's
state
a new
wants.
cause of action. Let them come with a new writ application.
Contempt application, can the court deal with these merits?
My lord, I was humbly praying, my lord, if your lordship can impress upon them, my lord, another round of litigation, another.
Can that be done? Does the law permit, sir? Please show me the provision.
But so far as the, my lord,
Contempt application, that is not possible. Isn't
my
it?
lord, that is there, my lord. Fact remains,
Your
my lord,
lordship's
in
order
similar
is-
case, my lord, of the same LA case, my lord, they have provided market
What's
value.
the authority with all these
My lord,
examples?
my lord.
Let
My lord
this
will
contempt
kindly,
application be disposed of.
my lord will kindly record, my lord.
I can
Our
only record disposal, nothing more.
No, my lord, our submission, my lord, that is. Yeah.
He tries to open up a new dimension
No,
of
that
the
is
case.
the conduct of the state, my lord. The state cannot distinguish between in the same LA case, my lord. For some petitioners, they are paying.
You have a very
market
good
value.
ground to file another writ application. Do it. Whether I have complied this order dated 25th 11th, my lord's order, I have complied with the my lord's order.
My lord has stated, my lord, it has in accordance with law, my lord. If you see page 35 of the contempt application, lord, at least, my lord, this submission can be made, my lord, it is not accordance with law. Because according to law, they have decided in other matters in similar matter, my lord. Similar LA case. This is, my lord, the malafide attitude, my lord.
Exception used by the applicant petitioners to the affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph learned counsel for the applicant's petitioners submits that the alleged contemner has not acted in terms of the order under contempt and has discriminated between persons similarly circumstanced with the petitioners. Paragraph the present application has been filed for non-compliance of the order passed by this court on 25th November 2022 in WPA 11771 of 2018. Stop. The decision taken by the authority / alleged contemner cannot be dealt with in the present application on merits. Paragraph. Since the order under the order under contempt has been substantially complied with, comma, the contempt application being CPA and such is disposed of. Paragraph, there shall however be no cause as in certified website.
But, my lord, petitioners will be at liberty to.
The law grants you the liberty.
My lord has
Not
my
necessary.
lord has recorded, my lord, substantial compliance. That is why, my lord, I am praying for that, my lord. My lord, there may be some difficulty, my lord.
No. I have recorded your submission.
Grateful
Next.
one.
My lord,
16 Millard, I appear on behalf of the petitioner, Millard.
my lord, please matter there is well.
At 12 fixed, my lord. 76, 77, 78.
Let me, since I've taken up this matter, let me just deal with this. Let me have a fixed matter. I'll show a fixed matter as well. এটা পরে fixed matter. পারে না? $77, $78. Which matter? I'll just deal with one. I've already taken up one contempt application. Let me finish.
This
Yes.
is the classic case, Millard, where Millard, a 80-year-old senior citizen has been harassed, not like anything. Millard, a order which has been set aside by this court. Millard, the similar order has been passed in this contempt petition. Millard, the order is Millard at page.
We have complied the order.
Yes, Millard, they have, Millard, I have received the order. Millard, I will file an exception. I will definitely file an, but Millard will kindly permit me 2 minutes. I will show that how Millard, affidavit of exception, Millard, is with regards to facts. Millard, on law, I will show that they have not complied with the order. Millard will give me 2 minutes. Millard will kindly see page 635, Millard, of the contempt petition. That is the order of Millard. Millard will kindly come to page 636. The third paragraph. Strangely, the compensation was assessed in terms of a government order dated 21st July 2005, though the land was utilized in the year 2017. That thereafter, Miller direction was passed to assess compensation in respect of the Act of 2013. Now, Miller, they have again assessed based on the valuation of 2000, based on that notification. First point. Second, no hearing was given to us. No hearing was given to us. No chance was given to present the deed of 2017.
That's the order.
Now,
Is the
thereafter,
I have annexed with my compliance. It is easy. It will be easy.
Section 80, which specifically says interest has to be paid. Well, that is law. I am not on fact.
Yes, yes.
Not done. Well, they say the order has been complied with.
Yes.
They say the order has been complied with. And
They have
admittedly,
assessed now
the
the
first respondent has not complied the order. Well, an immediate rule should be issued against the first alleged contemptor. Well, he has changed his position. He is not there. But during the time when he was to comply the order, he has not complied the order. He should be rule be issued against that person. I will kindly see Millard the order Millard passed by the LA collector. Kindly see Millard. No interest, no hearing. The notification which was categorically.
Where is the order?
Yes, Millard.
It will be easy to your lordship, my lord. I have annexed with my lord and my affidavit of compliance, page 10.
Page 10.
My lord, my affidavit of compliance.
I have annexed my lord's copy. I have not been supplied with the compliance.
No.
My lord will kindly come to
I have
the
submitted.
order. The order.
Yes.
SS করে দিয়েছিস 57 লাখ
The second last stage of the order. The second
না
last
না
stage of
আমাকে
the
তো
order.
এনেইছি হয়ে তোমরা তো
Where is the final order passed? I cannot find out. In the affidavit of compliance?
That is my lord's order.
My lord's order.
The compliance.
My lord will have annexed this, my lord. My lord, I am reading with my lord what I have stated in my.
My lord, I am giving you the order copy. My lord, this is the order which they have
annexed, my lord.
Which they have. My lord,
Affidavit of compliance.
Compliance, my lord, your lordship kindly turn to page 15. Art 2. Art 2.
Read petition. Read petition.
এসএস করে দিয়েছে
Compliance.
Yes.
It has been assessed.
It starts from page.
My lord, this is the order.
It starts from page 40. Page 40.
Where is the affidavit of compliance?
I'll possibly give to go. But just now, my lord, I have handed over.
Just now you have handed over this. This is statement of facts.
No. Affidavit of compliance.
Affirm তো
Affirm.
ওটা নো দ্যাট ওটা আমরা আগে দিয়েছি।
Yes,
Wait
it
a
is
minute.
compliance.
My lord will kindly come to page 16 of the
Page
affidavit.
14, my lord, it's whether that is the order.
Lord, let me place my case, they will get their chance. My lord, kindly come to page 16, my lord. After going through the sale data, it reveals that no sale data for classification non-Julie. My lord, this was also, my lord, I dealt with the writ petition.
Go through
That
the
there is
entire
no-
order.
I am going, my lord.
It will
My
not
lord,
be, my lord, it will
instruct me how to place my case.
If it is,
Yes.
if it is non-Julie, my lord, then it,
Father,
which,
let it complete.
yes,
Yes.
After going through the sale data, it reveals that no sale data for classification, Noel Judy or Pakka Rasta is available in pursuance with the guideline issued by the Land and Land Reforms Department, Government of West Bengal, right so and so, dated 7/12/2015 for preparation of compensation on land acquisition in tune of National Highway, read with the Right to Fair Compensation Act of 2013. It is mentioned that if sale data for particular class of land is not unavailable, another guideline issued by the Land and Land Reforms via memo
এটা
number
আমাকে কি
60
করে অ্যাপয়েন্টমেন্ট করলো
dated
দেখো তো,
21st July
এনএইচ আমাকে
2005
অ্যাপয়েন্টমেন্ট করলো কি করে?
maybe follow.
এলার
And this was
করেছে।
categorically argued before the writ court. And after going through, Millard, that order has been Millard, this new order has been passed by which fresh assessment was directed under the Act of 2013. And they are again, and Millard, now Millard, interesting. The Act of 2013 never says that if a land is valued at ₹100, you pay 50% of that. They have categorically done that. The land is valued at ₹4 lakhs odd for 1 decimal of
Even
land.
before I go into merits of the order, please show me one line that the petitioners were heard before this order was passed.
That is not, my lord, reflected with the order.
They've not been done.
Reflected with
If
the order.
says that,
So the order has not been complied with, let the alleged contender come. with
But
the-
yes, Millard, such order after giving any opportunity of hearing by your lordship.
Yes,
Your
of
lordship,
course.
kindly go through your lordship's order. I have annexed with my lord page 10. I am reading, my lord. The petitioners claims to be recorded owner of 11 decimal of land in plot number 1121 of Mouja, Kalika Khali, jail number 91, district Purbo Mendipur, by virtue of inheritance from its beneficiary interest. The state land was taken over by the state government without acquisition for the purpose of constructing and widening the road from Nandakumar to Digha, being NH 116B. In an earlier writ petition filed by the writ petitioner being WP member such and such, the
Please
court
come to the
by
relevant portion, Mr. Bandhu.
Relevant question.
Upon consideration of the submission.
my lord.
Upon consideration of submission.
Yes, my lord, it's clear. Upon consideration of the submission made on behalf of the party, the court is inclined to hold that since the petitioner claims compensation in respect of the area of 11 decimal of land in plot number 1121, the fifth respondent be directed to take necessary steps for measurement of the plot in question in order to assess the area of the plot utilized by the respondents. Such measurement be made in presence of the petitioner, his authorized representative, on the basis of.
Has that been done?
like that for that,
That has
it
been
is
done.
But after that, no notice.
And it has
for
been, my lord,
hearing.
stated in
And
my lord para-wise.
Today, my lord,
No hearing was directed.
no,
in the-
my lord, today they say that data of 2017 is not available.
But
My lord,
next,
I
my lord,
will
I'm reading.
produce hundreds of
Such
deeds of
measurement
the
be
adjoining
made in
area
presence of the
of
petitioner.
2017.
Such measurement be made in presence of the petitioner, his authorized representative, on the basis of the Moja map 1913 and 1914, to be provided by the petitioner to the concerned authority, and a report to that effect be submitted within 6 weeks from the date of communication of this order. Upon receipt of such report, the fifth respondent shall take necessary steps for assessment of compensation payable to the petitioner in terms of the Act 13 and in tune with the market value of the plot in question as in 27, upon consideration of the deeds of the adjoining plot submitted by the petitioner.
So where is this consideration, Mr. Bandhu?
Intermediate.
2017 deeds consideration.
10 to 17 consideration.
Where
My lord,
is
I'm
that
reading, my lord, from
compliance?
my lord compliance report, my lord.
Yes.
My lord, the paragraph 7, my lord, I'm stating, my lord, for your lordship, my lord, the contemner HON'BLE, my lord, has been transferred. The present, my lord, the Pakun Kumar Mondol, my lord, he has been appointed now. He is, my lord, affirming this affidavit. He is now,
Paragraph 8. Most respectfully, the following facts with the government in pursuance of the solemn order dated 3rd July 2023 passed by the Honorable Court in connection with the WT number such and such in the matter of Santosh Kumar Bhuya versus the undersigned being the land acquisition collector and the special land acquisition officer to be the fifth respondent in WT initiated proceedings. At the perusal of the order, it is transferred that there are two operative parts in the order of the Honorable High Court, Calcutta. A. The land acquisition collector and the special land acquisition officer HON'BLE Purbo Medinipur, being fifth respondent in WPA, has been directed to take necessary steps for measurement of plot in question in terms of Mauja Map 1930 and 1914. This part of the order has duly been complied with. Next, the land acquisition collector and special land acquisition officer HON'BLE Purbo Medinipur is further directed to take necessary steps for assessment of the compensation in terms of the Act of the 2013 and in tune with the market value of the suit plot as in 2017 upon consideration of the deeds, the adjoining plot submitted by the petitioner. The second part of the solemn order passed by the Honorable High Court has been complied with. Then, my lord, it is submitted that all the 4 deeds submitted by the petitioners are dated.
We're not of 2017.
No, that was with regards to the previous read.
That is after the 20.
That was with regards to the previous read. That's why, my lord, after
And
July.
for assessing valuation of the land, demand for calculating market value of the 27 conditions of the sale deed post transaction period, that should not be considered.
Yes, my lord. Now, my lord, order was passed by your lordship on July.
But
after that, my lord, measurement was done. Notice was issued to me. I was present for measurement. I supplied that the Mauja Map of.
And then next month, they also kindly turn to
thereafter
page 15. Order. Second paragraph, after detail. Madam, got it?
Yes.
For determination of the market value as mentioned in section 26, along with subsection and explanation of the right to fair compensation act 2013, reflected such and such. Sale deeds for 3 years, 2015, 2016, and 2017 of the Mauja, such and such, where the suit plot is situated, are taken into account. For determining the average sale price on behalf of the total number of sale deeds in which the highest sale price has been mentioned, are taken into account. The average sale price of similar type of land situated, Mauja, are taken up among the top half sale deeds.
Yes.
The sale data as supplied by the district register Purbo Medinipur in the year 2015, 2016 for the period 3 years are taken up. In order to render maximum amount of compensation, the higher sales value irrespective of area are taken into account. Top half of sale value of the classification is required to be sorted out from the collected sale data. It is worthy to mention here that from the available sale data, it is found that the market value is derived from sale data is mentioned above is higher than the set forth value as per provision of the market value as derived from sale data are considered here. All the 4 deeds submitted by the writ petitioners are of dates of, that is after June 2018, 3rd March 2022, 1st February 2022, 10th December 2021, and after the year, that is 2017. And for such assessing valuation demand for the calculating market value, that has not been by the
Lord, these deeds which has been referred, Lord, were filed before the order of my lord was passed.
The land of the petitioner is not Noyanjuli.
My
lord,
That part also
my lord,
clarified during the deed petition.
my lord, next reading, my lord.
Because I challenged that
Reader
order
is
only.
stated.
my lord, the record of rights said that it is Noyanjuli and Rasta, and that is the difficulty for the
assessment has been done. 57 lakhs, my lord. Next page assessed, my lord. Page 70, including solicium and after. And it has been, my lord, communicated to the petitioner.
Yes, my lord, now.
and my lord, now the difficulty is my lord, I
Only, my
am the requiring body, the National Highway Authority.
my lord,
I have to
required
acquire the
body is
land,
the
I have
result
to
of-
pay the money. Now, if it is Noyanjuli, I cannot acquire. Noyanjuli cannot be the private land and it cannot be acquired.
It has been utilized.
My lord, if it is utilized, even Noyanjuli cannot be, my lord. My lord, I have, my lord,
without paying anything?
If it is non-Anjuli, my lord, it is the government land. If any recording is non-Anjuli cannot be the land of the petitioner.
The order of this court in appeal.
My lord, I have not challenged.
So you are only.
My lord, the record of rights is the non-Anjuli and the Rasta. In respect of the Rasta, we will acquire, we will pay what will be the current market value under the new act.
Now, my lord, only one thing.
Are you a party to the contempt application?
Yes.
My lord?
Yes.
Yes, yes.
Why don't you come back with a report
My lord,
in the form of an affidavit, because this is a contempt application?
my lord, I shall file the affidavit, my lord. Today, my lord, I have got the instruction. I have made the my lord, the query from the additional land district magistrate. How much land is there non-Anjuli and how much land is?
The relevant documents. The district magistrate's statement will not really do.
My lord.
Now, my lord, only.
You want to come back with an exception?
My lord, I will
Please
come
do that.
definitely, but my lord, kindly see.
My lord,
that
then my lord, my lord,
Along with your exception.
my lord, my lord, my lord, then my lord, I have to.
For 2 minutes. My lord, today they were the party to the writ petition also. The concept of non-Anjuli, my lord, today they are saying non-Anjuli. My lord, initially they say it was a shoot plot. My lord, this is that classic case, my lord, where there's said the record of rights doesn't exist. Then they come with the concept of shoot plot. This court, my lord, turned down, said no, it's a Vastu land. You have to pay compensation for Vastu at that juncture for 1.65 decibels of land.
Annex the relevant
My
documents.
lord, all these are today, my lord, on law, my lord, they say 7 lakhs, okay, fine. My lord, interest, page 8, section 80, my lord, 2005 notification set aside by this court. They have, my lord, valued at that notification only. My lord, an 80-year-old has been made to suffer from 2017 for payment of compensation. My lord, then let the road be blocked. Then let the road be blocked. My lord, this way, my lord, the state respondent cannot be.
Let the requiring body also come back with an affidavit.
My lord, I shall come with the affidavit.
Submission is
24th, my lord, I will file my exception
not
by
so
that.
early, cannot be done. Let me see. Affidavit of compliance submitted on behalf of the first alleged contemner is taken on record. Paragraph. You are number 2.
No, I am a number 2.
Alleged contemner number 2
My lord,
seeks to submit a report in the form of affidavit in this matter. Paragraph. Learned counsel for the applicant petitioner also seeks to use an exception to the reports.
Just.
To the affidavits, to the affidavits. Paragraph, let the matter appear under the same heading on 13th February.
My lord.
Lord,
Please exchange your report.
My lord.
My lord, alleged contemner number 1, my lord, Shamol Kumar Pal, my lord, he has already, my lord, gone to a different post. New incumbent, my lord, Tapon Kumar Mandal, he's, my lord, I believe the alleged respondent number 3, that he is appearing for 3, and then he is appearing for 4.
Yes.
My lord, my lord, 1 has not complied with the order. My lord, that part, my lord, should be, my lord, he has, my lord, when he was in chair, my lord, he nastically, my lord, behave, my lord, I shall put it on the affidavit, my lord. But he should be, my lord, he has not complied with the order, my lord.
Please come back. Yes, the specially fixed matters.
Deeply.
Yes.
Not only 17 is very small, my lord. I have served the copy, passed your lordship.
76.
Fixed at 12.
76.
Yes, you want some time?
Now, here, automatically, your lordship reached at 12. Your lordship can fix any day, my lord, this week, my lord, I have nothing.
Let him come.
On the day after tomorrow, take the matter.
Yes, my lord, I have.
I want to fix it after the 22nd, but still 22nd, I'm dealing with another determination.
Take it. 20,
After 22nd. 22nd.
29th.
20.
My lord, not Monday.
Not Monday.
Yes, Monday, my lord, I have.
The 30th?
Huh?
Tuesday?
Twist. At 10:30, my lord. Stop matter.
10:30, not possible, sir. Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading on 30th January 2024.
Yes.
All the three matters? Same.
All the.
76, 77, 78.
At 12 noon.
Marked
March.
at 12 noon. Marked at 12 noon.
Item 18,
17.
item 17.
17, my lord, I am for the pursuant to lordship's order, my lord, I have served a copy of the contempt application upon there is contempt, my lord. They have received. This is my affidavit of service. My lordship's order is page 17. According,
Ninth respondent.
my ninth respondent is my lord.
Special Land Acquisition Officer.
Yes. Special Land Acquisition Officer. And after that, my lord, I have pursuant to lordship's order, I have made an application, page 20. Thereafter, they have hold an hearing to the petitioners. But after hearing was taken. But after hearing, no order has been passed till date.
Mr. Dev was appearing in the writ petition.
Howrah. Howrah. Achha.
Give me some time and I'll comply.
Didi.
Affidavit of service. Paragraph on the alleged contemner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 21st February.
Sir, Didi.
555.
My lord, I am for the petition. The affidavit of service. Sorry, affidavit of service is being affirmed. Now there is an urgency in this matter. I have served upon them, Lordship. I undertake to file the affidavit of service in course of the day.
That is
It's
required.
being,
I just want to see.
it's being affirmed. It's coming, Lordship.
Not today.
No, there is an urgency, Lordship.
Should have served then.
Lordship, we have already served. It's getting affirmed. Lordship, may I just bring that
Let us get
unaffirmed
the
copy?
service.
I'll just send them to get the unaffirmed
Just
copy,
not
Lordship.
come back tomorrow.
Lordship, can you give a passover, Lordship? I'm just getting.
Passover is not granted. I cannot discriminate.
Lordship, only one thing, Lordship.
It is so urgent, sir.
It's very urgent, Lordship. The only thing, Lordship, kindly. Urgency is that, Lordship, the notice, Lordship. Notice dated, Lordship, in page number 63. This is the notice of the Ministry of Road and Transport of Highways, Government of India. It says that I, Sri such and such, Project Director, NHIA, or Kolkata, on period inspection of the highway land and information received by me, am satisfied that unauthorized occupation has taken place on the highway situated such and such.
Have you filed the representation?
I have filed representation. I was called for the hearing. I participated in the hearing, and after this hearing, Lordship, this representation was not considered, and it was stated that you have to go to the court and get the order. Otherwise, it's not possible. That order was not passed nor given to me. These were orally told. Now, Lordship, it's a flat. It's an apartment which is made
I'm
there.
sorry, I cannot hear it unless you serve.
Lordship, it's served, Lordship.
I cannot show that it's served. Only not today.
Lordship, kindly keep it tomorrow, Lordship.
Not today, that is what I'm saying.
Lordship, matter will remain at its
Mention
own
it as
position.
not today.
556.
This is my application. That matter, stars of the time should not be dictated. You also convinced that the order should be set aside and the joint secretary should be directed to decide the issue. Well, this is the matter where the time, well, there are five years lease period. Due to the penalty imposed by the authority, huge penalty, I was stopped and that was carried to the joint secretary. In appeal, joint secretary said this is not correct. The only penalty amount for shortfall to be deposited and extra excavation beyond area is not correct. That's why that earlier order of the ADM was set aside by the joint secretary. That part of the penalty amount, 3,76,000, I have deposited. Carrying order was issued to me, but for that reason, 3 years, 3 months, I could not excavate. That part should be added to my lease period. That was my earlier application before them. That was decided by them, saying that we do not have the jurisdiction. It can be decided by the MDDCL. MDDCL remanded it to the ADM, saying that we do not have the authority since the lease is executed just before the coming into force of the concession. Again, your lordship set aside the order of the ADM, saying the MDDCL to decide. In contempt, ADM passed an order that is challenged before your lordship at page 48.
48.
48. Long order. The reason for rejection is 51.
Yes.
Middle portion. Hence, the demand cum show cause notice was rightly claimed by the DLLRO in 2015. But the DC did not rely upon the order of the demand and followed by the process of connected adjudication, the demand according as ordered was submitted by the lessee on 4/6/18. It is pertinent to mention that the order of the district magistrate collector 2016 over non-issuance of CO due to non-deposition due demand is still sustainable. This is incorrect. And not challenged before the court of law. Because of this, the issue framed over the notice dated 29/5/2015 is considered and decided against the claim of the petitioner. This is one of the ground. Second ground is, on the other hand, the issue over the concern of the extension of lease period for 3 years, 3 months, as demanded by the petitioner on behalf of the deceased lessee, is not sustainable in the ambit of WBMM rules 2002 to clarify as regards renewal of existing mining lease executed under West Bengal Minor Minerals Rules 2022. The Joint Secretary to the Government of West Bengal Department of Industry, Commerce and Enterprises Mine Branch expressly passed a speaking order on 26/3/2018 stating there is no provision for renewal. My case is not for renewal. Therefore, this order 26 March 2018, though it is quoted here, in this order, your lordship kindly sees the said order as page 24. (25) is the operative part. Last paragraph, last 3 lines. Hence, the allegation about extraction of sand beyond the lease area is not established, as the plot number is the leased area in favor of the Naresh Chandra Bosu. The petitioner in Naresh Chandra Bosu admits that there is a shortfall in quantity, such and such shortfall amount 2,47,086 that was directed to pay. This was corrected. Next page, 3,76,840. This has been paid by the petitioner. Next page, 27. This was paid. And this was paid when? After the order of the Joint Secretary in 2018. They are saying 2015 I did not repay it. On that basis, carrying order was issued for 3 months. No renewal is possible because new act, new concession rules has come. But in terms of the lease agreement, if there be any force majeure condition, then that period of lapse will be added to the lease period. That is the lease agreement. Therefore, my learned friend Mr. Saha proposed to pass an order directing the joint secretary to decide the issue. And Mr. Dey also considered to that. But since there was no time on that day, your lordship postponed this matter.
Because the appeal was preferred before the joint secretary challenging the two part of the suspension. One is for shortfall production and another is for extraction of sand beyond his leasehold area. So, lordship, that part has been held that, yes, that has been decided. So, lordship, kindly, because on earlier two occasions it was relegated to the ADM. ADM ultimately decided that no, there is no provision. So, it would be appropriate to direct the joint secretary mines branch, who earlier decided the appeal,
And
to
your
take a
lordship
decision.
recorded everything in your lordship's order. My lord.
Joint secretary. Yes.
33, your lordship has recorded everything. Then it will be easier to consider the issue.
Respondent number 2 may be directed.
For extension, not for renewal.
So at present, it is only for extension.
Yes, only extension.
That period which was suspended by, yes.
Petitioner seeks extension of the long-term mining lease. Granted in favor of her husband in 2013. Stop. An earlier writ petition, being WPA 654 of 2022, was filed by the petitioner praying for a direction upon the concerned authority to extend the earlier petition was also for extension.
Yes.
To extend the period of lease which expired on 25th November 2018. Stop. The relevant portion of the order passed in the said writ petition on 4th February 2022 is required to be set out. Page 33. It is submitted, okay, but to no effect. Paragraph. By the said order, comma, the additional district magistrate was directed. In
Yes, earlier ADM DLLR was directed.
Additional district magistrate and district land and land reforms officer, comma, Paschim Medinipur, was directed to consider the representation submitted by the petitioner before the authority. Stop. The additional district magistrate and district land and land reforms officer, comma, Paschim Medinipur, turned down the representation of the petitioner by an order passed on 12th October 2023.
Gotcha. Page 37.
On the ground that the lease of the petitioner could not be extended in view of the West Bengal Minor Minerals Rules, 2002. The petitioner seeks reconsideration of her representation by the
Second respondent.
second respondent, who the earlier order of the second respondent is
আগের অর্ডারটা কোথা থেকে ছিল?
page 24.
Page 20. Earlier joint secretary orderটা।
37. Page 37, that was set aside by your lordship.
না না page 24.
Joint secretaries.
Page, it starts from page 24. The relevant portion is at page 25. First paragraph, last portion.
Yes.
By the second representative, বলুন তো? By an order passed on 13th March 2018 in compliance with an earlier order of this court dated 9th November 2017 in WP number 3515 within bracket W of 2017 held that the allegation about extraction of sand beyond the leased area was not established and the petitioner / lessee was entitled to extract sand till the period ending 5 years from the date of possession, that is up to 25th November 2018, upon payment of the penalty due to shortfall of extraction. Stop. Paragraph. Why do you assail the order impugned?
My lord?
Cannot be challenged only because it was passed by the ADM DLLRO.
No.
What is the ground for your challenge?
Challenge because ADM DLLRO passed an order. My lord, that is not correct. The opinion,
Why is it not correct? That is the
because that first part saying that the first ground, the ground of rejection is that demand of 2015 was not deposited by the petitioner. This question does not arise because this demand was challenged to the joint secretary. Joint secretary decide, thereafter I deposited. But this has been the ground. Second ground, on the ground of renewal, my prayer has been rejected. My prayer is not for renewal. My prayer is for extension.
very well. কি বলুন last night? Paragraph. The order impugned rejects the prayer of the petitioner on twofold grounds. Colon dash. Firstly, since the demand come show cause notice was not complied with by the petitioner, and secondly, comma, since there was no provision for renewal of existing mining leases as claimed by the petitioner. Stop. The first ground of refusal taken by the additional district magistrate and taken in the order impugned has been decided in the order dated 13th March 2019, passed by the Joint Secretary, Department of Industry, Commerce and Enterprise. Stop.
2018,
Yes,
13 March 2018.
13th March 2018.
Lots.
2018. Thank you. Though the petitioner sought extension of his mining lease for the period lost by him
Due to suspension, order of suspension.
due to the order of suspension, comma, the concerned authority has turned down the prayer of renewal of lease, which was not sought by the petitioner at all. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since the order impugned does not reflect the actual state of facts and has refused the petitioner's prayer on grounds not pleaded at all, comma, the order is required to be set aside. Paragraph. Accordingly, the order dated 12th October 2023, passed by the Additional District Magistrate and District Land and Land Reforms Officer, Paschim Medinipur, is set aside. Paragraph, the second respondent, paragraph, the Joint Secretary, comma, Department of Industry, comma, Commerce and Enterprises, comma, being the second respondent here in comma, is directed to consider the when did you file your representation? Representation submitted by the petitioner dated
I have not annexed the representation. I mean, annex for it.
This is not annexed to the representation.
Let him consider.
Can you say the date?
Well, date after your lordship's order, I
New file.
নতুন filing টা নেই এখানে।
না order এর পরে
এটা কোথায় গেল?
you can grant liberty to file a fresh representation.
Will you do that?
Well, since it is being set aside, well, fresh representation will create that problem.
What is the date of your representation?
Well,
That can be considered.
as 26 July 2021 at page 34, your lordship order, it has been specified. Page
number
34.
Page number
26 July 2021.
Yes, that is the reference.
26 July 2021. Within 1 month?
Yes.
1 month? Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, and without being influenced by any observation which may have been made by this court or by the other authorities in the earlier orders, in accordance with law.
May I just
Paragraph-
request one thing, the representation, it should be forwarded to the joint secretary,
Yes.
because I believe it was
A
not.
copy of the
Pablo কোথায়?
Tarakun, the decision
Pablo
taken by the
কোথায়?
authority shall be communicated to
Malad-
the
Malad-
petitioner
Malad,
within a
may I-
week thereof.
My lord, your lordship kindly direct me to send this order with the copy of the writ
representations,
writ
yes.
petition.
Let a copy of
Writ petition is, my
Let a
lord,
copy
said
of-
everything.
this order along with a copy of the representation and the writ petition be communicated to the second respondent by the petitioner at the earliest.
Lordship.
Disposed of which. Yes, next.
Hey, Rajiv da, এইটা নিও, ওটা নিও না। Lord, I appear for the game. My lord, before my learned senior friend proceeds on merit, my lord, some technical issues, my lord, I like to address. My lord. Initially, the writ petition was filed challenging one acquisition proceeding. When and lordship, pursuant to the direction passed by your lordship, we have filed our report, where we have shown that entire plot was acquired in two phases, in connection with two acquisition cases. So they were sought to challenge that subsequent acquisition also, and liberty was given them to amend that amendment application was filed, and that was allowed. And they have filed the amended writ petition, a copy of which has been served. My lord, some certain facts, my lord, which has not been disclosed in the writ petition. On the contrary, I find, my lord, a false statement has been made in the writ petition, for which, my lord, certain documents I need to produce before this court by way of affidavit. If your lordship kindly consider one paragraph, I'm not on merit, one paragraph, paragraph 21.
Yeah. 21 of the writ petition.
21 of the amended writ petition. I have been served with a copy of the amended writ petition. I do not know whether that has been filed or not.
Petition?
Amendment petition filed করা আছে।
It is still not on record.
No, no, my lord, in the writ petition itself, only the prior portion has been, my lord, corrected.
Whatever may be, you have served a
We have
copy.
served an amended writ petition to the respondents.
You should file also,
Where is it?
and also it needs to be marked which portion has been added.
Yes.
Relying on the amended writ application.
No, in the previous writ petition, it has
Yes,
been
because
corrected.
copy has been served.
Copy may be served, but whether your lordship has granted liberty to correct the amendment, I don't know whether don't have the order sheet.
The order, if your lordship kindly looks, the order dated 16 November.
Yeah, that's so.
The order records writ petition be amended accordingly.
Amended.
But we
It
have
needs to
served,
be amended.
My lord, what happened in this is, my lord, the original writ petition has been, my lord, corrected. Pursuant to your lordship.
why have you served an amended writ petition to the respondents?
Corrected in the original writ petition.
Yes.
Correction has been effected.
No, only the-
If,
It has been written that pursuant to the deed granted by.
Well, may I peruse once your lordship's original writ petition?
Writ petition has been amended in terms of the order.
How it has been amended, my lord? Only with the correction with the leave.
Yes, yes.
but I have been served with a fresh copy of the writ
It's
petition.
a fresh copy of the writ petition, the same.
My lord, only the
The
prior
amended-
portion, nothing,
So nothing amended.
Yes.
nothing amended.
You compare with paragraph 21 with the writ petition, you will find it is same.
If that be so,
আমি আগের পিটিশনটা পড়েছি এটা বোঝা গেল
That is so.
আমি আগের petitionটা পড়েছি।
তাহলে এটা একদম নাকি
Lordship, kindly come to the writ petition. First paragraph 17.
whether if the lordship was to take up the matter, my lord, then I will start. I will not allow him to start.
19. No, I mean merit. I am not on merit. Just
what? Paragraph 19.
It's sufficient if only the prayers are amended. No, it has to be brought within.
No, if the that will do by amending the prayer, it is do the amendments are correct, then it can be done.
I
The
will
amendment-
argue
the
on that point
petitioner is also required to be amended, then a phrase application has to be filed.
whether without the pleading and grounds.
No, that will fail. The prayer will fail.
There was
Their prayer will fail.
there was a direction for amendment of the writ petition.
Yes.
But that has not been done. Only the prayers have been amended.
Prayer has been amended. If the prayer amendment is commensurate with the pleadings already there, that will face the consequence.
But not already there because this is a subsequent event.
No, maybe. Then the prayer amendment is redundant.
Why don't you come back with a yes?
Then the prayer is redundant. If there is no pleading and the amendment prayer is amended, then it is redundant.
Neither pleading nor grounds.
Can. If you want to file an amended writ petition, that
I am
also you
totally in
can.
dark about that, my lord. I am ready with the writ
Yes.
petition.
That apart.
Yes.
Because of the fact,
Include that in the writ petition. You have not done that.
no, why not? In the amendment petition, my lord, we have stated everything and only we.
In the amendment petition, you have stated
We
it.
wanted to, my lord, only amend the prayer portion of the writ petition.
You
that-
don't require any other amendment in the writ
My lord,
petition.
may I give me 1 minute time? I have to talk with him. Petition e কিছু amendment petition e কিছু include করে দিস pleadings.
No,
Sir,
nothing.
position,
Nothing
তাহলে আবার?
is really. As it is, only the acquisition case has been added with the in the prayer along
Without
with the
any pleading.
whether they can do it or not, there we will argue that.
No, that can be done because this is, my lord, the wrong typographical error was there. That's what is correct.
No,
Nothing
no,
else.
added.
Not
One
the
acquisition
typographical
case
error.
was added. আগে 77 ছিল 91 92 অ্যাড করেছে।
Add করলে তো
You
pleading
were
correct
aware
করতে
of
হবে।
the previous
It
proceeding.
was not corrected.
Then you have to correct it. তাহলে করতে হবে, নাহলে হবে না। Ultimately succeed করবে। You have to
And there should be some averment in the body.
certainly,
of the
otherwise
petition.
cannot
There is
be.
nothing.
Cannot be done.
The entire writ petition speaks of one
Then the writ
acquisition.
petition will fail.
On that ground.
That is up to him.
So
But
please
even
come back. I just grant you an adjournment without.
Well,
recording.
assume
Yes, yes. Otherwise, my lord, prayer is there without pleading. On that ground, it will go.
assuming, my lord, if he wants to proceed on that basis, even then, my lord, what I am taking this, having regard to the statement made in the writ petition, that is completely false. And
False?
even after
Correct.
making this,
That is on merits.
no, that is why my lord, I seek liberty to file a supplementary report annexing all these
You have already filed a report.
already filed it.
So you want to come back with a supplementary report.
Supplementary
That
report.
liberty is granted.
Yes.
Let him
Kindly
come
back.
grants me, or I shall produce all these documents.
Learned counsel for the KMDA seeks to use a supplementary report in the form of affidavit in this matter. Paragraph, learned counsel for the petitioners also seek accommodation. Paragraph, let the matter appear under the same head, under the heading Group 1 motion. On 21st February,
That's it also.
So they will proceed on the basis of this.
let they come back with an amended.
No, amended it.
The direction was for amendment. That has to
for
be complied
amendment,
with.
yes. Let me grant liberty. Act line add করুন on prayer of the petitioner. Liberty is granted to file an amended writ petition on that.
Liberty, not liberty. It was granted, not complied with, my lord. I was seeking extension of
Yeah,
that.
it
Your lordship
was-
directed.
Writ petition be amended accordingly.
Yes,
was the
that has not
direction.
been done.
So let me grant liberty to file an amended writ petition.
I say liberty was already there. It's time
Order
to file.
618,
So my lord is fixing on
21st February.
21st. In the meantime,
Please exchange your reports in the meantime.
yeah, of course, great. Much.
Next. Raji, Group 1 motion.
558.
Yes, 558.
I beg to appear for the petitioner. My lord, in this petition, my lord, we've challenged an order passed by the land acquisition officer in pursuant to a direction passed by your lordship. But what I find, my lord, that order is not being part of the, it's entirely my fault, my lord, not been annexed, my lord. May be granted a leave to come back tomorrow with a supplementary affidavit, because that is the subject matter of challenge in the writ petition. Though I have pleaded that thing in my writ petition, but copy is not being annexed.
Not today.
Grateful lordship.
Not to.
हाँ ठीक है
559.
559, my lord, in this matter, my lord, I am appealing for the petitioner.
Yes.
Physically very weak.
You're not well
জ্বর হয়েছে
or having pitepuli at home.
No, my lord, I never skip.
What are the evidence, sir?
Yes, yes.
Now, can you turn to page 36? This is, my lord, relating to settlement of a land to a minority school. Initially, my lord, page 36, your lordship will come. This is a letter from the Joint Secretary to the Principal Secretary, Government of West Bengal Minorities Department.
On the panchayat is done.
The track report is not there.
Then how?
Panchayat, my lord, no, it is Panchayat. I can skip, my lord. Panchayat is now. I'm telling the final order of the Joint Secretary.
Punch. You'll expunge panchayat?
Yes. Panchayat now, Panchayat is not necessary. Now I'm challenging the order of the Joint Secretary. State is represented. Man, can I turn to page 36? The undersigned directed, my lord, got it?
Yes.
The undersigned is directed to refer the above subject and to state that the creation of such and such Shomiti, a school registered under the West Bengal Society Registration Act, furnish a proposal to the department seeking long-term settlement of such and such as detailed in the schedule below. Free of cost. The purpose of the learning of school for students of the particular community. The said land is under the occupation of the said society and the said society is running the school for poor students of such and such community in the name and style of Shikha Niketan High School. At least 30 years. As per the present policy followed by the department, there is no scope for considering the settlement of this said land with the said society at a nominal salami and rent for the said purpose. If the Minorities Development and Welfare Madrasa Education Department thinks it fit to allow the long-term settlement of the said land with the said society at a nominal salami, the only way to allow such settlement is to obtain prior approval of the cabinet. So it is the main thing, the cabinet has to take decision. Now, my lord, I turn to the next page. This is the representation was made. I'm skipping over the portion where now, my lord, I've been approval and other things. Page 53. Can you turn to pass?
Page
53.
Yes.
This is the order passed by this on the earlier occasion. The land is agreed upon the Land and Land Use Department, who said the long-term lease should be granted in favor of the school. The Joint Secretary of the Government of West Bengal, by a letter issued to the Principal Secretary to the Government of West Bengal, Minorities Development and Welfare Madrasa Education Department and such, recorded that the land could be settled in favor of the school upon obtaining prior approval of the cabinet. Such approval was sought for by Deputy Secretary by letter dated such and such, but no further communication was made to the petitioner. Since the school has been continuing in the plot question, please prefer direction upon the concerned authority to the school at the earliest. For consideration of the submission made on behalf of the parties, the court is inclined to hold that this is the matter pending consideration for the cabinet. Consequently, directed to take necessary steps in regard to communicate the decision. So this is the thumb and substance which where my lord was pleased to direct the Principal Secretary of the Land and Land Use Department to communicate what is the cabinet took the decision. Because my lord, why my lord was pleased to pass this order on the basis of the letter which is there, my lord, can you turn to page 51.
So no decision has been taken as yet.
Yes, the decision.
Now, my lord, can you turn to the last order which was passed?
Opposite the salami, but they have not.
Yes.
They have challenged that.
Page 59.
Page 59. Page 59 is the sum.
Yes.
This is, my lord, the procedure which is adopted for the purpose of settlement of present market land, same was given. It is not for that purpose the cabinet has to take the decision. There is no decision on the part of the cabinet. My lord, kindly, I am putting this question to myself. From this page 59, my lord will find any decision of the cabinet, or it is a mere work done by the Additional Secretary Government of West Bengal, whereby he adopted the provision which is for the purpose of settlement of land private party for the purpose of long-term settlement, 30 years. It is not that for that reason it is pending for the before the cabinet. Whereas
Have you submitted the written consent?
no, this 1 crore and odd ballot, this is not the for the purpose of, that is why it was placed with the cabinet. The earlier letter and order, my lord, will find that everyone is saying that it cannot be done that way. It is pending for the cabinet. Cabinet will take the decision. I want to ask, put this was to myself. Let the state come forward and say the cabinet have taken this decision. Then I am out of court.
A consent was called for from you.
Yes.
Whether you're ready to pay the amount. Have you responded to this
No,
letter?
no. I have challenged that. Because this amount is not a decision of the cabinet. This decision is not a decision of the cabinet. Previously, my lord, your lordship find all the documents and the communications were made that yes, this is a cabinet is seizing on the matter that your lordship find page 52 also may read out the. It is expressed that the department is the view that period of settlement should be exceed 30 years, should be not less than the rate of the riot at the locality. Land review for this. Moreover, it is clearly mentioned that the cabinet meeting period of settlement amount to salami rate and annual rate should be specified. Lastly, it is requested as soon as the cabinet approval is obtained of a copy of such approval together with the copy might be sent to this department for further action. I put this question to myself, whether this cabinet has passed this decision and what is the decision of the cabinet? Because it was a specific direction passed by your lordship on the earlier occasion. What is the decision of the cabinet should be communicated to the petitioner.
Yes, Mr. Paul.
My lord, it is recorded in the order, my lord, your lordship kindly see page 53. Please submit that as reading by it is contained on behalf of the petitioner. The petitioners are in possession of the plot in question and run the school, namely Shiksha Niketan High School, Delhi. The first petitioner made an application on
sorry, my lord, sorry.
2003 for issuance of part in respect of the land which was agreed upon the land and land department who had a long term lease would be granted in favor of the school. So that is the long term school lease. The Joint Secretary of the Government of West Bengal by a letter issued by the Principal Secretary of the Government of West Bengal, Minorities Development and Welfare Madras Education Department on 3rd February 2010 recorded that the land could be settled in favor of the school upon obtaining the approval of the cabinet. Such approval was sought by the Deputy Secretary Administration by a letter dated such and such. But no further communication was made to the petitioners. Since the petitioner's school has been containing the plot in question, the petitioner pray for a direction upon the concerned authority to issue patta long term in favor of the school at the earliest. It is their prayer to issue patta or lease in favor of the school. Then, my lord, upon consideration of the submission made on behalf of the parties, this court is inclined to hold that the matter is pending consideration before the cabinet. The first respondent be directed to take necessary steps in this regard and communicate the decision taken on the matter in issue to the school within the stipulated time frame.
So where is the cabinet approval?
I don't know, my lord. I have no instruction. They'll have to take instruction to the
Let him come back with instructions.
Yes, your lordship. I am not on that. This is what's what point.
Not my, it is not known to me. In view of the above, the petition is disposed of, directing the first
It was
respondent.
admitted in principle. Only cabinet approval was
It was
necessary.
it was the submission by the learned advocate who representing the minor the earlier petition.
No, no, no.
No, it is there also.
What was my lord's view, my lord? In view of the above, the writ petition is disposed of, directing the first respondent to take necessary step with regard to approval or the grants of lease or patta in favor of the school and communicate the decision taken in this regard to the school authority within 2 months from the date of comment. It is my lord's order.
Yes.
Then, my lord, the decision, my lord, has been taken. It has been communicated on page 59. With the
Is
reference to
59 a cabinet decision?
I don't know, my lord, I have no such instruction, my lord, to that effect. But here, my lord, it has been settled that the additional secretary to the government of West Bengal wrote a letter from the additional, my lord, With reference, I am directed to inform that IGS, CSR, such and such funding valuation of students such and such applied by for LTS by the President Shiksha Niketan school for the school. They have, my lord, applied for the long-term settlement LTS. And accordingly, this valuation has been calculated. Therefore, you are requested to submit your written consent to this department for payment of salary and annual rent as stated above for subsequent processing of the matter in compliance with the direction of the Honorable High Court in terms of such and such. It has been communicated on 30th March 2023 to their consent. But I don't know, my lord, what happens next, my lord.
What was directed in the earlier petition was cabinet approval.
No, that was the
And the
submission
secretary
before
was
by the
directed to
landed.
take steps.
That was the submission before the Honorable Court, my lord. The cabinet will take decision and it is going to do that.
The
Without
first
cabinet
respondent be directed to
and
take
your
decision
lordship
steps.
direction to take decision, my lord, page
Now,
59.
the principal secretary has been directed to
In
take the
view of the
decision.
above,
How it can be
it is-
delegated to a subordinate? When my
Approval
lord,
of the
order of the court should be done in a manner which has been directed. The principal secretary has
I
to
don't
be.
order page 58 again 54 I am reading, my lord. In view of the above.
Upon, you should read from upon consideration of the submission. That is also
Yes,
part
my
of the order.
Yes, your lordship directed directing the first respondent to take necessary step with
Yes.
regard to the
Even prior to
approval of the grant of patta. I don't know who was the first respondent, my lord, in the
Principal
matter.
secretary.
Principal secretary.
Principal secretary. And he has
How
taken
the
decision
subordinate authority can
and
take a
communicate the
decision?
decision. He has taken decision and communicated the decision. If he may agree or may not agree, my lord.
he was not supposed to communicate and take a decision. He was supposed to take the
Then I have to take
cabinet
instruction
approval.
whether cabinet has approved or not.
Yes.
Then I come back with the my lord the instruction.
This court is inclined to hold that since the matter is pending consideration before the cabinet, the first respondent be directed to take steps before the cabinet. Where is that compliance?
Then my lord, I have to take instruction. Without instruction, well, I can't submit before your lordship.
Affidavit of service. Oh, Tarang Kurun on prayer of the
Panchayat be my lord deleted because according
yes,
to me.
on prayer of the petitioners, comma.
You cannot put it on. You know,
The name of the Pradhan, comma, Kapasharia Gram Panchayat, comma, being the seventh respondent herein, comma, be expunged from the cost title of the writ petition. Paragraph. Affidavit of service. Paragraph. Learned counsel for the petitioners submits that the order passed by this court on 19th January 2023 in WPA 3475 of 2019 has not been complied with till date. Stop. The said order directed the first respondent therein, comma, being the, who was the first respondent? In the
No,
earlier
the principal secretary, Department of Land.
don't know, my lord, they have not annexed the certified copy.
do you have a copy of the writ petition?
My lord, I'll bring it, my lord.
Being the secretary, comma, Department of Land and Land Reforms.
Land.
Department of Land and Land Reforms, comma, Government of West Bengal. He बोला the sentence. To take necessary steps with regard to approval of grant of patta / lease in favor of the school by the cabinet and communicate the decision taken to the school within a stipulated time frame. Stop. Paragraph. Learned counsel for the respondents submits. Respondents seeks to take instructions with regard to compliance of the said order. Paragraph. Let the matter appear under the same heading on 31st January.
But I'm trying, my lord.
No, good.
Item 583. Malad, it was upgraded version. Malad,
I'm at 560, 559 now.
now Malad 583 extreme urgent. It was upgraded, but your lord
It'll appear tomorrow.
tomorrow Malad some preference. Malad,
It'll appear
otherwise
tomorrow. Let me see.
this will be infructuous.
দিদি ওটা উপরের দিকে দিয়ে দিন 583.
দুটো আর কানেক্টেড
Item 6. Item 679, extremely urgent, my lord. Matter is in the list, my lord. My whole big field has been closed by virtue of an order of ex parte order of injunction. No notice has been served. And the learned trial court, by disposing of the ad interim, my lord, dispose of
Number 19 matter.
679. 679 of Justice. Order of Mr. Shocker, my lord. Extremely urgent. I mentioned for Monday, my lord. It is in the list. Ex parte order, my lord, while disposing of the ad interim, the main injunction has been made absolute without hearing us.
Come back tomorrow.
Tomorrow at top, my lord, subject to your lawsuit approval, my lord. I know your lawsuit list is heavy, my lord.
দিদি কালকে এটা উপরের দিকে রাখুন তো
Top of the list.
Court number 19
I'm grateful to your lawsuit.
বলবেন কি বলেন তাহলে আমরা Court number 19 এর top.
I'm extremely grateful, my lord.
My lord, may I take one indulgence, my lord?
Tomorrow is 3:30.
Today morning, my lord has granted me a leave. My lord, the person, my lord, who came before is on the basis of a power of attorney executed by the, my lord.
Yes, the department had
Now, my lord,
told me.
department is saying that it has to come through the embassy.
Oh.
No, my lord, Section 14 of the Notaries Act, my lord, kindly sees, my lord, it's a reciprocal obligation in India. No, CPC is, my lord, when, my lord, on evidence. My lord, this is not evidence.
This is not an evidence.
My lord, kindly takes the Notaries Act, it's and column 2 in bottom, Section 14 of the Notaries Act.
Section 14.
Section 14. This is Notaries Act.
Reciprocal arrangements. For
Yes.
the Notarial Act.
And Roman 2 in bottom, my lord will find USA notary done in USA is recognized in India. That has been recognized by central government. And the person who is now swearing an affidavit before this honorable court on the basis of power of attorney, he is present before the administrator to cause an oath before the High Court commissioner. My lord, he is present. But a power of attorney to sign on behalf is not an oath, it's a power which is been recognized by the notary of USA.
Court deals with power of attorney. I've seen that provision.
Yes, but the person, my lord, who is now before High Court to affirm an oath, he is before the commissioner.
It's on the power of attorney. It's not for.
He is acting on the basis of this power of attorney which is being given by the notary of.
It has to come through the Consulate General.
No, my lord, this need not. Because this is a reciprocal obligation where India has to recognize this. And his stamp, the notary of USA has put it, it's stamped. It does not require, my lord, through consulate.
This is done by the US notary.
Yes, notary. Kindly see. This is the headed Joseph. But I will be guided by the Notaries Act, not 139. For the purpose of his power.
This is for a limited purpose specified in the notification.
Yes, this is that notification where he gives me power, only for that power.
This is not the notification, this is the act.
My lord, Roman 2,
Government
Roman,
has to-
my lord, Roman 2 bottom, my lord, USA notaries. Just a small Roman 2, my lord. Under section 14, my lord. My lord, purpose of a notary, my lord, he says, I have seen him causing this notary. My lord, kindly see the last statement of the notary before the US. This is the limited purpose under the section 14 as well. Or under the Notaries Act. That a notary swears that I have seen that person signing on behalf of, in front of me.
I have to see this and come back. No, I'm not really convinced with this.
My lord, and Justice Bhattacharya in one of the matters, my lord, has also allowed this. Because this is the limited purpose is he has seen Saptarshi Chaudhary to cause this power of attorney in favor of the person who is now present in this High Court. Who will swear an affidavit before the High Court that I am filing this revisional application on behalf of Saptarshi Chaudhary on the basis of this power of attorney which is caused in US? This is under 139. He has to take an oath before the commissioner that yes, this is the power of attorney by virtue of which I am swearing on oath.
I have to go through the provisions. I'm not convinced. Go through the provisions.
Otherwise, my lord, he has to come down from USA to cause an affidavit. Affidavit is an oath, I understand.
It has to be through the consulate general.
No, my lord, it is not required because I tell you, affidavit is an oath. There is no doubt. But he is causing a power of attorney. That is not an affidavit. In the High Court, my lord, when we
Didi, CPC টা দিন তো।
no, my lord, have এই তো দাও দাও আমার কাছে আছে।
ওনার কাছে আছে।
My lord, 139 is oath on affidavit. The Didi আমার কাছে আছে। My lord, the first line is oath on affidavit. 139. Please, my lord, 139. My lord has got it, my lord.
Yes.
Oath on affidavit by whom to be administered. My lord, this power is not an affidavit. And the person on the basis of the power has come before this High Court to cause an oath on affidavit. The commissioner has to recognize this power. And he will cause an oath on affidavit.
Let me speak to the department after I rise. Please wait for some time.
Yes, yes. My junior would be here, my lord. I'm going to other court to argue on it. I may take by my mobile.
Yes.
In a very compelling situation, my lord, I am to draw your lordship's kind attention, my lord, with regard to a matter, my lord, which has.
Department কে inform করতে হবে একটু Final department.
Your lordship's kind attention, my lord, with regard to a matter which has been taken up for hearing just before recess, my lord, before Honorable Mr. Justice Mohammed Nijamuddin, my lord. But his lordship has been pleased to hold that the matter relates to land. So,
mentioning, sir, this is not the mentioning time. Please come back tomorrow.
no, my lord, as
Yes, group 7 matters.
his lordship has been pleased to release the matter, my lord.
This is not the mentioning time.
As your lordship does. Then at the first sitting of the court, as your lordship.
Come tomorrow 10:30.
My lord, as you.
Yes, group 7 matters.
Group 7 motions, item 595.
করেছো ফ্রেশ ক্যালকুলেশন ওই কই দাওনি তো
দিয়েছে তো ওকে পাঠিয়ে দিচ্ছে
কাকে
কাকুলিকে পাঠিয়ে দিচ্ছে তো
ফ্রেশ ক্যালকুলেশন না জানি তো
আমাকে তো বলছে কাকুলি
কেউ
এই তো
কিছু
কাকুলি দত্তর
ওখানে লেখা আছে কিন্তু আলটিমেটলি
পাঠিয়েছে
পৌঁছয়নি
তোমরা যে দিয়েছিলে সেই বেজে ক্যালকুলেশন করে পাঠিয়ে দিয়েছে
দেখি চিঠিটা দেখি
তোমার চিঠিটা মেলাও But this is a face calculation, on the basis of the letter written by learned advocate on record of the Mr. Chatterjee's.
Have you gone through this calculation?
earlier I have gone through it. There are certain mistakes I have pointed out and sent a letter to them for making correction.
This has a
Now this is the correction.
This is also wrote a letter to the learned advocate.
That I have not received. My learned advocate on record is not received.
And calculation was made. As per my lord direction, as well as learned advocate written, the certain mistake is there, they have calculated the entire.
একই তো করেছে 7-5-20 তো 30-9-20 1-4-21 তো 31-9-21 1-10-21 to 31-21
তারপর দেখো তোমরা যেগুলো করে দিয়েছো
মানে সেগুলো তো আমরা বলেছিলাম সেগুলো হবে না সেগুলোই করে দিয়েছে এটা কি ইংরেজিটা পড়ে না নাকি
1-1-2003 আমি চিঠি জানি না, I do not know about the
letter.
I have given you letter.
No, no, I have not received that. That is send it to department. I cannot.
This is going on for a very long time. This
Yes,
is
my lord,
a
I have pointed out.
assessment.
I have pointed out. Your lordship kindly see. No. Your lordship kindly see.
I do not know this contents of the letter. That is the difficulty.
এটা কার সই?
কোনটা? এখানে তো
আমরা যে
law office-
তথ্যটা পাঠানোর সঙ্গে সঙ্গেই তো
আমি দিয়ে দিলাম ল অফিসারকে ডেকে দিয়ে দিচ্ছি।
যাই হোক।
যাই হোক পেয়েছে তারা পেয়েছে বলেই তো আনসার দিয়েছে।
No, মানে this is the original calculation they have given. Your lordship kindly see. On earlier occasion.
5th December.
On 20th December.
এইগুলো কি ক্যালকুলেশন করে দিল? No, here 1st January to 31st December 2023.
ওটা তো লাস্ট।
এটা তো লাস্ট। এটা তখন তো ক্লিয়ার আছে।
ওটা তো লাস্ট। ওটা তো কেউ বারণ করেনি।
না ওয়েবার স্কিমে চলে গিয়ে সব ফ্রি হয়ে যাবে। এখন কেন
ওয়েবার স্কিম তো আমার ক্ষেত্রে অ্যাপ্লিকেবল নয়।
কেন?
Only registration in West Bengal এর ক্ষেত্রে।
তাহলে ঝামেলাই চুকে যায় তখন।
It's the period of restriction.
Yes. After this after I have received the same, immediately I have informed Mr. Debra. Mr. Debra informed to my clerk that he will not be available during the vacation. Please send it to the department. I have sent it to the department. Immediately, Mr. Debra informed my clerk that please send one copy to me. Law officer is coming. I have informed him. He will take. And law officer taken one letter. And the same mistake they have done.
এইগুলো এলো করতে হবে।
Same mistake. This is deliberate. I understand. How long my client will continue this matter, I do not know.
Included, Mr. Debra, the same thing.
Same thing. I have indicated the period that this period will not be indicated, should not be included in my letter.
In principle, admitted by the
Yes.
respondents.
And that has been recorded in your lordship's order. And you also kindly see in my letter, I have clearly indicated to the department that this is the period should be included as per my lord's order.
Difficulty, my lord, the letter was not with me. That is the main problem.
But please come back with a final assessment. This is going on and it's all wrong assessment. The same thing is being repeated day after day.
Yes.
Same thing.
Debra, I would request you to look into this personally because it's going on for a very long time. Assessment has to be made and they have to pay the amount.
Lordship I fix next Monday I shall take.
Very well.
Next Monday I shall take. Thereafter Lordship
This is your copy.
Lordship kindly check.
Now, if 22nd,
আমার একটা letter
এক
দেবে।
minute, দিচ্ছি। If 22nd, just now I have seen the television that central government may declare holiday on 22nd because of the inauguration of Ram Temple. Maybe, may not be, I do not know.
24th?
24th
So let it be on 22nd. If it is not 22nd, the holiday.
24th থাক না বাবা কি দরকার আছে?
Right, it should be-
আননেসারি দুবার থেকে লাভ। তোমার একটা কপি দাও, তোমার রিসিপ্টটা তোমার কাছে রাখো। এই রিসিপ্টটা তোমার কাছে রাখো।
Let the matter appear under the
Wait a
same
minute,
heading on
wait.
24th January
এই অফিসার রিসিপ্টটা তোমার কাছে রাখো।
paragraph that on prayer of the state petitioner. On prayer of the state, the matter is adjourned. Let the matter appear under the same heading on 24th January 2024. Paragraph, the state respondents are directed to furnish a fresh assessment in terms of the orders passed by this court on the adjourned date.
My lord, my lord,
Please look into the matter, Mr.
my lord, I shall.
Several dates.
I shall, my lord.
May I take back that paper?
After 18, my lord, departments comes here because the Gangasagar Mela is now going on. After 18, everybody is available. I know. The lordship knows, my lord, Gangasagar Mela is there. আমার বলেছে অনেকবার আমি যেতে পারিনি, অনেকবার বলেছে। 24th, my lord.
596.
Chief Doctor.
Noted that was that time copy of
96.
আনমূল্য জায়গা
better I'm appearing on behalf of
এটা গুলো আছে না ও মেলা দেখায় ও এই দেখা আমার দেখা
on 29 November, better was taken up. One directed the London Council, Mr. Sen, appearing on behalf of the state, not directed to submit the report in the form of every week. Mr. Sen, no, Daniel. Mr. Sen. Number 24. Yeah, he's engaged on number 22.
Yes.
Mr. Sen is engaged in court number 24 on Lake. His matter is going on.
কি করব
Come back sometime next week.
Yeah, next, I have no.
Not next week. Come back on 30th.
Yes.
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th January. Easy.
13th.
30th January.
30th.
30 is not present in the court.
31st, 97. 31st January.
1st February.
Jayanti?
1st February.
1st
February.
No. 1st February is a Thursday.
2nd February.
31st.
31st no, থাকবে না।
অনুষ্ঠান আছে।
অনুষ্ঠান আছে।
Second February.
2nd February.
Jayanti?
Second February. My matter.
হ্যাঁ, 2nd.
This is 2nd February.
Next. 597. Yes.
Hello, this is a petition, writ petition, my lord. Today,
আবার থাকতে একটা কপি দিল আমাকে দিচ্ছি আবার থাকতে
yes, my lord, this is a matter lordship will remember lordship has conducted extensive hearing on previous few occasions.
Jayanti? কাটতে হবে
So the petitioner was an operator of one part.
Respondent?
Fifth respondent is the legal metrology, my lord. On the previous occasion, lordship will remember the lordship
Mondal is there.
lordship directed them to file one supplementary report annexing relevant documents.
Yes.
Today, 5 minutes back, my lord, I was served with this. No documents have been annexed. Kindly see the report. No documents have been annexed. The contents taken herein is just a reiteration of the earlier report, stating nothing,
Where are the relevant documents?
because the report, lordship, on the conspectus of the fact, my lord, the only point of contention.
Filed a report. Previously, we filed a report. With the report, my lord, we have annexed all the documents.
Where are the documents? You are appearing for respondent number 5.
Led by Mr. Answer.
Well, earlier the documents, the report which the learned legal metrology filed, my lord, they annexed few documents there. Those documents were not satisfactory, not complete documents. Lordship directed them to ascertain whether there are other reports at the time when the incident occurred. Because the report which they have filed and they are relying at present is the report subsequent to a lordship's direction when they conducted the women. They conducted it on 12th occasion to see whether the wagon in motion way bridge is functioning or not properly. Because this is a second round of writ petition. First writ petition was disposed of by your lordship with a direction to conduct event of the empty parcel van and also to see whether the in motion way bridge is functional, and if it is not, then the appropriate steps may be taken. That order is there. Now, my lord, the report which they have filed on previous occasion, legal metrology, they have only highlighted the rules, and what they have done after your lordship order was passed, they have conducted the vehement on 12th occasion, which appears from the said report and also from the previous one. 60 readings were obtained. And out of these 60 readings, my lord, only 4 readings have been annexed here. And out of these 4 readings, my lord, there are anomalies. Now, my lord, I placed your lordship the manual, the railway manual. Your lordship, remember on the previous occasion. The railway manual empowers the railway to conduct check of the payment in motion weighbridge half yearly basis. That is on per 6 months, they have to conduct the payment and they have to affix a report that it is functioning properly at the weighbridge. That documents was directed to be affixed with the supplementary report. That is not, Railways is here, Railway has not done so. Railway has not affixed any report in the,
Railway has not filed any report at all.
yes, Railways have filed, but they have not annexed any
As far as the
certificate of,
certificate is concerned, well, final certificate, that has been procured from the legal metrology state of West Bengal. Mr. On the last occasion, directed state respondent to file report, supplementary report, including all documents of the as far as certificate is concerned.
Yes, but no document.
That is not available. That is a
now the question is this, my lord, I am very specific on this particular issue. Roshi will kindly turn to page 53 of my, তোমাদের দায়িত্বটা দেখিয়ে দিচ্ছি, reply to the report, page 53.
53 of the reply.
53 of the reply to the report, exception, my lord, which I have taken. Page 53. Why I say Railway is also duty bound to file a report before this, including annexing that document, clause 1431. Roshi says, testing of weighbridges by weighbridge inspector. This is the Railway's duty, my lord. All weighbridges will be tested half-yearly basis by an inspector of mechanical department. After testing, he should furnish a certificate for each weighbridge showing that it has been adjusted and tested. This certificate must be displayed in the weighbridge house until the next inspection and the issue of fresh certificate. The date of each testing should also be painted on the weighbridge. This certificate, Lordship directed them to at least affix in this document, supplementary document, and no such thing has been done. My lord, my respectful submission is this: the entire exercise done by the Railways is illegal and dehorsed their own rules. Because petitioner is an operator, petitioner has booked one consignment at Ahmedabad that was re-verified, weighed there. I was allowed to dispatch the consignments there as the weight was found within the tolerable limit. Now, once they sends and dispatches the consignment after payment, my lord, normally they cannot do the second payment. Now, second payment was done without notice to me. And without notice to me, and legal metrology was also not there when the second payment was done. Now, that reason, my lord, as because there was anomaly in readings of both the railways, I approached before this honorable court with a prayer for payment. Lordship has passed an order which is appearing at page 111 of the writ application. Lordship, kindly see page 111.
Yes. The empty
Yes.
was,
Yes, yes. Well, two aspects are there. Lordship, kindly come to page 111, last 3 lines. The petitioner submits a consignment showed alleged overloading either due to increase in the weight and the empty parcel van which carried the consignment or due to defect in the in-motion weighing machine in which the consignment was weighed. The petitioner prays for direction upon the authority to examine the in-motion weighing machine at Padmapukur, Shalimar and reweigh the empty parcel van such and such attached to the train number in terms of section 79 of the Railways Act. It is contended on behalf of the Railway Authority that the in-motion weighing machine has been checked and verified by the metrology department and is found to be functioning properly. It is submitted by the learned counsel appearing on behalf of the 5th respondent that he has no instruction in this regard. Upon consideration of the submission made on behalf of the parties, the writ petition is disposed of by directing the 4th respondent, that is the railway, to reweigh the empty parcel van as referred to earlier and check the in-motion weighing machine at Padmapukur, Shalimar in presence of the petitioner and the controller legal metrology being the 5th respondent hearing or his authorized agent within the 4 weeks from the date of communication of this order. Since the petitioner has already paid the punitive charges on protest, it is expected that in the event the weight of the empty parcel van is found to exceed the normal limit and or the in-motion weighing machine is found to be defective, the punitive charges slapped on the petitioner to be refunded to him within 1 month from the date of the direction thereof. The 4th respondent or any other officer authorized by him shall communicate the place, time, and date of the payment inspection directed earlier to the 5th respondent or his authorized representative and the petitioner at the earliest. Now, this was your lordship's order.
This was complied, 160.
Now, my lord, they issued a notice.
The different case, my lord.
Just, no, this is a connected matter.
No,
Separate matter, can you see?
WPA number certain.
This is a connect earlier round of litigation. where you didn't have earlier round, which has a connection with this present parcel van. Now, my lord, this order was passed. They have issued a notice to me. I went there to take part, but I was told to leave as because it has crossed the scheduled time. After my absence, they conducted the payment, and lordship, the 4 readings were affixed with the report, shows that it is not functioning properly. Now, on this score, my lord, there is single bench judgment and division bench judgment, which I have annexed.
What is the admissible limit of difference?
Admissible limit is, my lord, 20%. They say, legal metrology says that 20%, my lord, of the total weight, if it differs, then it is within the permissible error. Now, my lord, second aspect is with regard to the speed restrictions, which is very important, which the railway themselves, which the legal metrology themselves says that if the payment is done exceeding the permissible speed limit, then there will be anomaly. Lordship will find from the report of the legal metrology. Now, legal metrology is not saying whether the second payment was done within the permissible speed limit or not. Neither the railways are also saying. These are two important aspects. Railway is silent to that aspect. That at what speed the wagon was taken through the weigh machine, nothing has been said so far. The speed limit is prescribed in the manual. It has to be within 10 km/h to obtain a correct reading. Neither at the time of second payment, my lord, legal metrology was present to see whether the speed limit was maintained or not.
What is this speed limit referred to in the
Yes. In the report, my lord, kindly come.
216 of the writ petition. You have annexed these documents.
Yes.
3.60, 2.10.
My lord, this is the report of the in motion. This is a report of the revamment which was undertaken, page 116 onward.
Previous
No, after your lordship's direction was passed, it was done in presence of the legal metrology and the railways. The empty weight of the parcel van is 32 tons. But at the time of revamment, my lord, they have seen, kindly see, that is 31.60, then 31.80, then 31.20, then at last 32 tons. And all total 60 readings were obtained as per the report says. Only 4 has been annexed.
It's within permissible limits.
If it is within the permissible limit, then lordship kindly ascertain one aspect, which lordship was pleased to direct the railways, that what was the speed limit at which the wagon was taken when the second repayment was conducted.
Next column, please. What is the speed?
It is the speed limit of when the repayment was directed to be asked.
Yes.
It was not this speed limit which was maintained when the incident occurred. The second payment, lordship, against which I have come. The speed limit is very important. If it is not passed through the proper speed limit, then there will be erroneous findings. And that is what the legal metrology has said in the report. And railways is silent in that respect.
Previously, are not on record.
No, speed limit has been maintained. My speed limit has been prescribed here.
The speed limit on the basis of which the punitive charges were
Yes.
not there on record.
Yes. Let you kindly see page 28.
Of the writ petition?
No, my lord.
I think before we proceed further, let us hear Mr. Mondal. Where are about the documents?
Documents, my lord, only the fact is this, as per the manual, which I have, lordship, have demonstrated that the railways have to ascertain themselves also on a half-yearly basis by putting a certificate that these are functioning properly. Now I say, my lord, the entire exercise of second repayment is bad and illegal and dehotes to the rules.
That has not been
Just
challenged, my lord. as far as
I have said so here.
Only challenged, my lord.
They cannot, when I am submitting, please allow me to place my case. The second payment ought not to have taken place when the first payment has already been taken place at the originating station. Originating station, lordship, kindly come to page 17 of my report. It is specific.
The guidelines.
Yes, page 17, Lordship, FM Circular 7 of 2021. 1.1. The originating station shall weigh at least. The originating station is here, the Ahmedabad station, my lord. The originating station shall weigh at least 20% of the total lease parcel traffic loaded in SLR VPs on daily basis in such a manner that the entire lease traffic originating from station is weighed in rotation. In case of lease traffic en route, the loading is permitted. This provision shall also be applicable on en route loading stations. Consignment loaded in indented parcel van shall be weighed before loading. In case it is not possible to weigh the consignments and loading station, the concerned CPS shall be recorded the reason for the same in writing and also convey the message to the destination station. Consignment once weighed shall not be weighed again except as per the provision of 5.0. My lord, kindly come to the manual, which is at page 53. Lordship, it will be clear that the exercise is illegal.
One 1431. That's the periodic check.
I have the manual with me. Yes. My lord, I am reading. Lordship, this is the manual I have taken. The railway receipts should not. Yes, this is at 141B. Lordship.
Annex the manual.
Yes, I have annexed, but not getting it.
It's point number
1451B.
yeah. Oh, you have not annexed 1451D.
Well, I have annexed it. You kindly see, this is the manual 1451B. You see, well, Lord, you kindly see.
— 1451C is there. Where is it?
B, it's the top. B.
Yes.
So, my lord, Lordship has seen that railway receipts will only be granted at the originating station if the payment is checked and verified by the railway officials. So that has been done. It is assumed that has been done here. So when that has been done, my lord, then there is no occasion of second payment comes because it has been verified by them. Now, my lord, kindly come to this provision which I have annexed at page 53 once of the report.
53 of your exception.
Yes, my lord.
Yes. Yes.
Page 53 is money receipt.
No. Of the
কোনটা?
report.
Exception.
রিপোর্টের কথা বলছি।
Page 27, my lord. Page 27. Sorry, my lord. Page 27. Page 27, once. 1.1.13 clause. These are rate master circular. That punitive charge 1.1.13, my lord. The punitive charges for overloading, if any, should be realized at the originating point itself. And it should be mentioned in the RR, that is the railway receipt, that if I have done any overloading, punitive charge has been assessed. That rake has been weighed and all the charges, including punitive charges, collected. There should be indication in the FOIS against this train that it has been weighed and it has been weighed. Revivement of such wagons, rakes at en route destination should normally not be done. There has to be an indication in the railway receipts that as I have overloaded. If there is no indication, I have not overloaded. Yes, my lord.
Annex the railway receipt.
Railway receipts, yes, at page 53 of the writ petition. This is the money receipt which they have given. Page 53 of the writ petition. This is the charge which I have to make. I have to payment I have to make before the railways. They issues this.
Where is the weight indicated in the receipt?
Next page. This is a manifest signed by the railways. This has been countersigned by the railways. Now when they allow the wagon to be dispatched to destination station, my lord, there is no indication that I have overloaded. And if there is a provision, my lord, if there is a surprise check, then there has to be a notice given to me. That is at, my lord, FM circular page 17.
Of your exception?
Exception. Now page 20 of the FM circular 7 of 2021.
Yes.
In case of dispute regarding overloading detected as a result of surprise check in respect of consignments of branded items which are of standard sizes and uniform weight with weight stenciled on packets such as dairy products and such, the number of packages in the parcel when detected to be overloaded may be counted and the average weight of the packet may be determined by weighing few packets on random basis in different segment in each different segment of the consignment loaded at the destination point in presence of the representative of the consignee and 2 gazetted railway officers, one from commercial or operating department and the second from any other department. Punitive charges already raised may be revised based on payload determined in this manner with the approval of senior DCM. This is a clear-cut provision, my lord. If there is a surprise check, let us assume, my lord, they have done a surprise check. The second payment. So that has to be done only after issuance of notice to me.
Yes.
That notice was not given. That is the reason I say, my lord, the entire exercise is contrary to the rules. And for that reason, my lord, punitive charges need to be refunded. That is my only prayer. Because exercise is bad and the railways have not enclosed the certificates as per the manual guidelines. Neither the railway has indicated at what speed the wagon was taken when the second payment of the surprise check was done. So these were the documents which were asked to be annexed by your lordship on the previous occasion. And they are annexing those documents which appeared, lordship, after your lordship's order was passed, when legal metrology came into field.
Today's report has no document.
No documents at all. And 2 adjournments were sought only to annex those documents. It's evident from your lordship's order itself on the previous 2 occasions.
Yes, respondents.
Was the earlier occasion according to the supplementary affidavit with the connection with the report, that report already submitted before your lordship.
But after that, documents were called for. Where are those documents?
Lordship, on the basis of the affirmations of the competent officer, the legal metrology department, according to the restitution of prayer C, kindly see the restitution prayer C. A writ in the nature of mandamus who issued thereof directing the Southeastern Railway Administration and controller legal metrology, weight and measurement, such repair and rectify in motion way bridge installed in Poddopukur, Salimar, which was allowed erratic reading as per impugned way bridge report such and such. So, my lord, it is the according to the erratic report, my lord, there is no, and that report is the reading that at the joint inspection at the time, it is the permissible. When the occurred the joint inspection in presence of the both party, that the joint inspection is the permissible at that time. So on the basis of the report submitted and learned friend already demand the such documents not placed before your lordship. So kindly direct the further direct, and it will take time to it.
How many more times do you expect the court to direct?
Now, which was praised that documents?
Certificate,
document?
certificate, certificate.
You wanted to file the documents today, so time was granted to you.
Lord,
So you're making the same prayer in a different cover.
the what type of the document? Earlier occasion already annexure.
Like you inquire them whether they have repaired it or not. Whether they have repaired it or not. It appears that they have repaired it. So when the incident occurred, it was defective.
Earlier occasion annexure P1 such and such already submitted before the lordship law.
Where are the
And
documents?
others is not available at this stage.
So we can take it.
So
that it was
I prayed
effective
for
at the right
further
time.
for your lordship 7 days time for clear instruction and file the another report is available or not. Certificate.
Well, then this report is of no value.
And
my lord.
according to the railway department, this is the total grievance of the petitioner.
Please take back your sub-report, supplementary. This is the supplementary report. This is of no use at all.
No use because no documents have been annexed, my
Same
lord.
document. Please file documents to show that the weighbridge was functioning properly and the weighment was done properly when the punitive charges were slapped on him, on the petitioner.
Will you kindly at least direct them to come up with any notice that they have issued to us when the second payment was done as per the policy. No such notice was given. And neither legal metrology officials were present when this second payment was done. It was only on the basis of a lordship's direction they came in the field. But prior to that, they did nothing.
Documents is necessary by the petitioner. What type of the documents is necessary?
Nothing. You have to substantiate your case. It is necessary for you, sir, not for the petitioner. To prove your case, you have to file your documents. Otherwise, the writ petition will be allowed. And you have to give back the punitive charges to the petitioner.
Kindly I prayed for 7 days time.
Though the fifth respondent has submitted a supplementary report in the form of affidavit, no document has been annexed to the same. The fifth respondent is directed to produce documents to show compliance of guideline number 3.2 of the Freight Marketing Circular number 07 of 2021. That is the notice.
Yes.
And also relevant documents with regard to payment of the consignment and correctness of such payment, on the basis of which punitive charges were imposed upon the petitioner. These particular documents are required. Paragraph, learned counsel for the fifth respondent seeks accommodation. Paragraph, let the matter appear under the same heading on 2nd February should be sufficient for you. Yes, next matter.
Instead of 2nd February, kindly take it up 5th of February. They do.
What? Very well, 5th February. But the document should be there on board of that.
Well, kindly make it that they should not take further adjournment, my lord.
No.
Already several adjournment they took.
Come back, let me see. It's 590.
I'm for the petition. 2023, your lordship has been extending time to file report. I don't know whether they will file a report today or.
My lord, absolutely,
Second report.
absolutely, my lord, wrong, misleading statement. What my learned friend is also doing on the last occasion. We have filed our report, but that was not sufficient to him.
Okay, so a comprehensive.
That was, he says, according to his my lord intention, our report is not a complete one. My lord, according to the ability and my lord the information,
Directed you to file a
I have,
comprehensive.
I made it, I made it. I will comply. But my humble submission is
Where
this,
is
my
the
lord, the
report?
last occasion, the report was ready and he collected it, you served a copy. He received it. He has not returned it, but he is not relying on that. But that must be on the court's record.
The court directed you to file a.
But I am filing, my lord, but earlier report, what my learned friend accepted, that must be in record. Because he has, he affirmed copy. My lord, KML, according to us, according to our ability, you are asking for unauthorized auto rickshaw should not be applied on. We have served, we have made a survey, we have instructed, requested police to take action. What more shall we take? But I have come with my lord comprehensive report. On the basis of that, my lord, some development has also been taken place. But I am, my lord, lordship, be kind enough to keep this report on record. That I have given you earlier, but you have not admitted, you have not disclosed it before the court. You could have said that I have received the copy, but it is not sufficient.
No.
But my affirmed copy, I cannot keep in my record.
No, paragraph 5, your lordship kindly.
That may not be satisfactory to you. My lord, this is our comprehensive report today I have made. But that report should have been on record. I am giving you, sir. No. You have not disclosed it. Because honorable court is, you are saying that we are delaying the matter.
Yes.
No, we are not delaying. According to our ability. No. Lordship kindly come. Lordship kindly, my lord, says. And the similar report, and on the same cause of action, my lord, also he has filed another writ petition also by the same writ petitioner. He wants to continue these cases.
Unless you stop.
We cannot. Our ability. We are the motor vehicles inspector, RTO. Our ability. We always work with the machinery of the state. Police is also there to help you, everybody. This is not the entire responsibility of the RTO.
You are indulging the operation of illegal operation.
Please, don't make all such allegations. These are all vague allegations. Also, kindly, my lord, come.
Given the number, operations area.
Now, my lord, shall I proceed on the basis of this report, or he will again ultimately take? He will reply to it.
My lord will kindly see whether it is report or not.
This is a comprehensive report. What I have said, lordship, kindly come to page 15. And 16, lordship.
Of today's report?
Yes, today's comprehensive report, lord, today affirmed on this day, today, lordship. Has your lordship got it?
Yes.
Comprehensive report. Now, my lord, may I place, my lord, the paragraphs which are relevant for this, my lord. Lordship, kindly come to page 4. Page 4. And, my lord, on this issue has been decided in another coordinate court also. My lord, I will place it also. Their police has been solely directed, you take action. You have sorted out. The police is to see what is wrong, what is right. Page 4, my lord. That an order was issued against unauthorized plying of auto rickshaws. Such order was passed since unauthorized auto rickshaws or originally plying in the route under the jurisdiction of ARTO. A letter was issued to the ARTO Barakpur by the Secretary RTA, North 24 Parganas, dated 21/11/23, requesting him to send the enforcement team at a regular interval henceforth and to take necessary action as per law against plying of unauthorized auto rickshaw in the route Sambazar to Barakpur. A list of valid permit holders are also forwarded to the concerned ARTO as ready reference. And it was further requested to submit action taking report. Now, my lord, what we have done here, my lord, we have sorted out the unauthorized auto rickshaw. We have requested the police, you take action beyond that, and ARTO to also to compare with this. Then, my lord, kindly come to next paragraph. That in compliance of the solemn order of Honorable High Court, the action was taken on behalf of the authority as reflected in the letter dated 21/11/23. It is a continuous process to stop the plying of auto rickshaw. Now, that another letter was also issued by ARTO Barakpur by memorandum such and such to take action against unauthorized auto rickshaw. A copy of such letter is also annexed here too. Now, the RTO Barakpur was requested as because the concerned area was under the jurisdiction of ARTO Barakpur, along with the list of the lawful permit holders. So we have given lawful permit holders, unlawful permit, those who are applying also. The list has been given. And the enforcement was done, my lord, paragraph 8. The enforcement was done by the ARTO Barakpur on 3/1/23. 2 numbers of vehicles were seized. Further enforcements were done on 4/1/24. When 2 numbers of unauthorized vehicles were seized, it was vividly informed by ARTO, Barakpur, by this letter dated 4/1/24, along with the report thereunder to the Secretary RTA, North Chobbish Purgana. A copy of such letter and report we have annexed here too. Now, my lord, kindly see next that there are more than 250 numbers of auto rickshaw route exists under the jurisdiction of Barakpur subdivision. There is only 7 MVI, non-technical, under the jurisdiction of ARTO, Barakpur, who are interested to enforce for enforcement against flying of the unauthorized vehicle. So, my lord, we have disclosed our capacity, capability, and everything. Now, my lord, that may not be satisfactory to the extent of or to the expectation of a particular auto rickshaw puller. Not others are here. One is saying, blaming that we are not taking action. Now, that another letter was also issued to the officer in charge, Noapara police station, for taking necessary action against unauthorized auto rickshaw in the route Barakpur station to Shambazar station on 4/1/24. Now, it is relevant to mention that on the pending issue and almost on the same subject matter, the same petitioner has filed another petition being numbered WPA number such and such 23. I'll actually leave to me place this. That in the identical situation, in a different matter, His Lordship, the Honorable Justice Obhijit Gangopadhyay, was pleased to pass an order directing Barakpur Police Commissionerate to take steps to seize unauthorized auto rickshaw. So here entire process came to an end up to police. We have given everything what is within our capacity, mean, and our record. We have done everything. We have forwarded to the police, and police is to do next of the work. And if any assistance is asked for, we shall. But here, my lord, it is very unfortunate to hear that we are taking time, we are delaying the matter. What does it mean? We are not sincere in taking action. So, my lord, I have given all these documents here, and we have also disclosed the authorized number of authorized auto rickshaws which are unauthorized. The lists have been prepared. We have sorted it out. We have given to police, and we have called earlier to we have called each and everybody. Only a few responded to it. So what more action could be taken? I request my learned friend to suggest you take this action. We cannot raid the house of the persons. Our duty from the record to sort it out. We have sorted it out, prepared the list. We have given the petitioner also. In our earlier report, we have also given it. Therefore, my humble submission, kindly dispose of the matter, giving whatever direction is suitable to your lordship. And my learned friend, if you want anything more within the periphery of the law, we bow down to comply it. But we shouldn't be blamed.
What am I to do? I am the authorized permit holder. I am seeing that several hundred auto rickshaws without permit, without registration have been operating. Your lordship can directly respond number one to file a report. This is not a report.
Further report will not be
then your
help in this matter because it is a continuous process.
It's a continuous
process. Again.
These references are wrong.
Kindly see it.
These references are wrong.
Auto has been seized out of 1,000 autos.
Yes. If we do not, whatever we have got, we have seized.
If you accept this report as a compliance.
Where is the seizure?
Yes. Kindly come to me this comprehensive report. Lordship, I have filed today. And this action has been taken. The matter came up Lordship on last 15/12. Thereafter, he was not happy with the report, though he received. We have given this report. No, you could have said that his report is here, but that is not complete.
You are not serious in taking steps.
Petitioner has given a list of auto
rickshaws.
He says to be unauthorized.
My lord.
What steps have you taken?
Yes, Lordship. Kylo, my lord, says, my lord. My lord, page 16.
Of your
comprehensive last report to define.
1616?
Yes.
Yes.
A list of valid auto rickshaw, 4 routes. Barakpur station to Sambaja Chorungi, 327. Barakpur station to Sambaja, 395. Has been enclosed herewith for ready reference. To ARTO, we are intimating all these. Number of auto rickshaw and everything. In a read petition number 977423, the Prashantu Sadhuka and others, the state respondents, it was mentioned that 404 number of autos are illegally plying in the said route. The list of alleged vehicle number mentioned in the read petition are also enclosed herewith. We sent notice to all 434 vehicles owners in the address mentioned in the Bahan portal, but either due to wrong address or some other reasons, only a few appeared. On 21/11/23, we sent a letter by memo number such and such to you to take necessary steps against plying of unauthorized auto rickshaw in the said routes, and accordingly filed an affidavit before the Honorable High Court mentioning the year to Barakpur will take necessary action against the unauthorized auto rickshaw. Now, the Honorable Justice, my lord, heard the case on 15/12/23 and rejected the affidavit. She directed to take at least some steps against the unauthorized auto rickshaw and also directed to submit another affidavit mentioning the action taken report. And in the meantime, the petitioner filed another WPA case number such and such in connection with the Prasanto Sadhuka versus such and such through the learned advocate Mr. Samanto. And here too, we have intimate for Milord, action details you have said. Then Milord kindly come. Now, Milord, to the secretary, this report has been given by the year 2, Barrackpur. Milord, that is page 17. Now, Milord, pursuant to the matter.
Page 17.
Not 17, Milord, 18. 17 is the continuation of that. Pursuant to the matter, as enumerated in the subject line and in compliance with the communication bring number so instrument of the Secretary Regional Control Authority, the office of the undersigned deployed MB inspectors along with the deputed MB inspectors from the office of the district magistrate North Service for Balasar to take necessary action germane to the flying of unauthorized auto rickshaw along the Sambhajar to Barrackpur. The report prepared in connection with the aforesaid matter is forwarded to your estimated office for your kind perusal. Now, Milord, next 19. Reference number, memo number so and so. Deployed MB inspectors. Now, Milord, 3/1/24. We have seen MB inspectors. Names have been given. Now, Milord, Sri Torun Balak, Barrackpur, and Simran, so and so names are given. 4/1/24. Sri Kaji Aminullah, Barrackpur. The names have been given. Now, Milord, pursuant to the communication as enumerated in the mentioned reference, the deployed MB inspectors conducted motor vehicles law enforcement activities against the auto rickshaws plying on contravention of the extra extent law in the Sambhajar to Barrackpur station route at 3 intermediate points or junctions. Desai Hospital, Netaji, Polli More, and Pinkal More, Garulia Main Road, so and so. These are the stops where the raid was conducted. Upon halting, the inspection team proceeded to inquire the drivers of the respective auto rickshaws regarding the status of the permits issued to them, if any, and whether they were flying with the issued permits at their disposal. The auto rickshaws given in the compendium below were seized and kept in the custody of the Nuapara Police Station, Barrackpur Police Commissionerate. These are the date and auto rickshaw what was available. The moment, Milord, where we little number of members, kindly see the situation, Milord, visual situation. The moment we come on the road, intimation goes everywhere. And Milord, all because they are very much sensitive. They know, they smell who are there and how police is acting and how RTO is acting. It is not Milord possible what Mr. Samanta has said, 340 I mentioned, you catch hold of 340. The way we have to proceed, whether the process is wrong or it is not, it is unintentional or intentional, not sufficient, he can point it out. But he cannot compel us. I have given you the name of 400. You go and find it out. Milord, I have over here. I have, according to him, it will not be over. It will not be over. If it is not sufficient, Lordship, let him take further steps.
MBI 1 is there. Well, is the government, my lord. Unauthorized operation of
I request, Milord, kindly, Milord, give the direction.
Direct the response of 1.
Give the direction, concern.
Pending further, it will be a futile exercise. Because this has to be a continuous
process.
There's continuous.
But today 2 persons coming, tomorrow another 2 will come. Then again another. What? No. You are one competitor on the line. Shouting, there is reason because you are blaming us. That's why I am shouting. This is a continuous process. You have named 400. He wants 400 to be ousted. He only will fly.
You have filed an objection also before the authority.
I shall file exception to the report, my lord. Your lordship kindly believe. So I come back with the report, my
lord. My humble responsibility kindly record. I say, my lord, this is our complete. We shall be taking. We are not saying that we are stopped. We shall be taking. But nothing more development will come forward, lordship. And my lord, the submission, the intention is. Number my lord will give, but we cannot go raid the house of the persons.
All fake numbers.
Reports submitted. Reports in the form of affidavit reports.
And according to us, this is a complete report as on date.
Of the respondents are taken on record. Paragraph learned counsel for the petitioners seeks to use an exception to the reports. Paragraph let the matter appear under the same heading on 6th February.
I am grateful, lordship.
It has to be a continuous process.
It has to be. That direction may, man, we are, these are duty. But it is not that it has to come to an end. He is saying 400, therefore 400 to be behind the bar. Then you will be happy. This should not be a desire. Illegality, irregularity, my lord, illegality, irregularity is a continuous process. That's why laws are there. We are to, we cannot make his client happy.
Next.
Grateful lordship. But any further date, any other report?
I shall be filing.
Mr. Shamant will come back.
Grateful, grateful.
আমি তো নাম্বার দেবো তারপর তুমি
No, no,
Next one.
599.
The two matter were tagged. The second matter by I am on the other.
600.
Your Honor, in this matter, we have taken one time on the last occasion for filing one exception to the additional report filed by the state government.
Sorry.
6th February.
But unfortunately, today we are handicapped by the Gangasagar Mela.
You want to use an exception?
I have already taken time, but that exception I cannot, I have prepared, but affirmation cannot be done because everybody went to gone to Gangasagar today.
You're the petitioner in the first matter.
First matter.
Second I am appearing on the other.
So it's being taken up together. Let it be adjourned.
Yes. Both matters are related. So one of that will be
On
hard for them.
prayer of the petitioners in 12778 of 2023, comma, the matter is adjourned. Paragraph, let the matter appear. Matters are urgent. Let the matters appear under the same heading on 7th February.
Yes.
Actually, yes.
7th February.
7th February.
7th February.
Next.
Six hundred one. The petitioner and matter was heard by your lordship and your lordship was directed to file him to the exception and file the report. And I have to file the exception, but he have to serve the judgment. But still
Where is your
the judgment is not.
Exception or judgment is different.
Where is your exception?
Exception is not prepared because he is to serve me the judgment. Because this is the matter.
Suppose he does not furnish the judgment.
Lordship directed.
You will not contact with an exception.
Lordship directed him to submit the judgment. Then kindly give me some time. I have to file my exception. Because this is the illegal flight. This is the illegal flight. Yes, Lordship.
Mr. Sen appeared, Mr. Sen did not supply the copy of the judgment. Division bench also directed and particular division bench were taken all steps and no further order except presently.
And in this
The counsel is referring to that judgment.
that judgment, your Lordship directed him to serve the copy of the judgment. That's why I did not prepare my exception.
Please
And-
serve on the next date.
And in this report is specifically admitted.
If you have the citation, the number, you can give it to her.
I can check it.
He is not downloading anything for that reason. Your Lordship directed him. And in his report, he is admitted that, and Lordship, 1 minute.
You want to come back with the exception? So come back. Learned counsel for the petitioners.
Without judgment, Lordship, then I.
Extension of time to use the joinder as sought. Paragraph that the matter appear under the same heading on 7th February. February. Next.
Well, I am for the petitioner, my lord. In this matter, my lord, Rule 83(1) of the West Bengal Motor Vehicles Rules is under challenge. My lord, your lordship directed me by the order 8th of September to serve the learned advocate general, my lord. I have served.
Anyone
If there is scope of interim order, let them file affidavit so that it can be heard out, my lord.
2384 এইটা প্রত্যেকে ঢোকা হ্যাঁ এই সেই Rule 83(1) of the West Bengal Regulations.
Who is representing the advocate?
Advocate কে আছেন?
Mr. Sen and
Learned counsel for the respondents seeks to use an affidavit in opposition in this matter. Paragraph affidavit in opposition be filed within 2 weeks from date.
4 weeks. Minimum.
Within 4 weeks from date, stop affidavit in reply, comma, if any comma be filed within a week thereafter. Paragraph, let the matter go out of this for the time being, liberty to mention. Next.
This matter, I am appearing on behalf of the petitioner. In the last occasion on 29th January, November, my lord was directed to file a supplementary affidavit. Mr. Sen is appearing on behalf of the state. In time that.
Have you used the supplementary affidavit?
Yes,
Yes.
I read it, my.
Filed it.
Yes.
Copy served?
Yes, I have.
But exception, taking the exception. At least,
No problem.
1 week time may be given. Already ready.
Exception to the supplementary affidavit. Supplementary affidavit submitted on behalf of the petitioners. Supplementary affidavit submitted on behalf, taken on record. Paragraph. The learned counsel for the respondents seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on 2nd February.
2nd April.
February.
February.
Next.
Well, next matter also same, malo supplementary date.
Next matter. Mr. Basu, your appeal. Same order.
7th নামটা কি আছে? 2nd হ্যাঁ ও
604. 604.
Oh, supplementary date.
Same order.
605.
Malo second round also same.
605.
Same. Supplementary date.
606.
Same. Supplementary date.
All on 2nd February.
607.
Same. Supplementary date.
Same.
Copy of sub longer.
সব নামগুলো দিয়ে দেবেন স্টেটের নাম
608. 608.
Anyone in 608? Petitioner?
অমল সেন লাগবে
No one for the petitioner? None appears for the petitioner, no accommodation is sought. Let the matter appear under the same heading in the monthly list of February 2024. Next.
609.
Petitioner? 609 petitioner? Same order, monthly list of February. Next.
609 practically not an infraction because they are challenging the practice that has been withdrawn.
Let it appear. She is not present. Let it appear.
That is.
Let there be another date. Let us see.
610.
I am for the petitioner. My lord, state respondents was directed to file report.
610.
No report is required.
Yes, you have turned down the prayer despite there being a vacancy. A report is necessary.
But my instruction would be, my lord, that
My lord, report is not necessary, my lord, on this score, my lord. On the, in respect of the self-same vacancy position, my lord, permit has been granted to the other operators without raising any dispute that there is no vacancy.
other operators may be a party, otherwise.
No, that not, this is not that route.
There was one vacancy in the particular route, despite which the authority said there is no vacancy.
Particular day, when the, my lord, vacancy arrived, particular, when the consideration was made on the particular day, there is no vacancy. After consideration made, after 2 days, there is a one permit was cancelled. There the vacancy arises, that is why my specific instruction, the vacancy would be notified by the authority.
So the petitioner should be given preference.
Yeah.
Let the petition be disposed of.
But, and simultaneously, this order should be stayed, should be quashed.
কোনটা? What will be বলে? এটা তো already বলে দিচ্ছি।
No, my lord, that, no.
What's the value? What was the only 3 line? My instruction. Then my lord.
On page 51.
Then go to my.
Oh no, not this route, or this route. But the self-same vacancy position has been relied on the self-same meeting, my lord.
Not your.
On the self-same meeting. So Lord, say kindly have a look on this.
Particularly there is no vacancy.
শুনেছিলাম ওকে বলছি
Yes.
You Lord, say kindly have a look. But this is self-same vacancy, my vacancy list. But item number 100. Item number 100. Well, on the self-same date, by another, he has been allowed.
On other route.
In respect of the other route.
Other route.
Maybe. But this vacancy has been relied on.
There is an explanation given by the authority. It was recorded inadvertently before the before the permit was cancelled.
Before the permit was cancelled, your lordship kindly have a look when the permit has been cancelled. No date has been mentioned.
Let a short report come. This has to be on record.
No date has been mentioned.
Deborah, please come back with a short report. Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 29th January.
29 January.
You can take the documents. Yes, next.
611. Lordship, in this matter, I am appearing on behalf of the Union of India. Lordship, in this matter, your Lordship directed me to file the report. I received the instruction, but my junior is not well due to he has not come to court. Lordship, give me some time so that I can file my report.
I appear for the petitioner. Your Lordship will recall, my lord, this is one of those cases, my lord, where, my lord, in my earlier writ petition, they sought for time, my lord, for filing report, and in between, my lord, they have terminated my contract. And I have challenged that order of termination.
Yes, Lordship, I received.
Lord, my lord will kindly give a shortest possible, my lord, date because
Lordship, he is not come due to his illness. He is not come.
Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph. Let them appear under the same heading on 31st January.
my lord, prior, my lord, service of the
Please have a
reports.
copy. And advance.
Lordship.
31st January. Next.
Hundred 12.
611. Okay, 11.
11 order पूरा होता है
Yes.
अच्छी तो report service side ready না দেন মাত্র একটা রিপোর্ট কি এক্সেপশন তো দেব না পড়ে দেখি না পড়ে
Yes, flying from Babu Ghat.
no madam this report is today
Want to go through this and come back?
today it has been handed over before the court I need some time to go through this and this required two exception to be filed.
Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 6th February. Please serve an advance copy.
But I am not on such a that on the court, Mr. SUVRA is there. He has handed over to me today itself. I will hand over him before this matter will appear.
613.
One the same. 613 is yes. Both the matters is one of the same.
The report is ready, Mr. Devan.
The report.
Yes, the issue is the same.
Issue is same.
Same order.
5 February.
Next.
614.
It's my application.
Yes, service complete.
Yes, yes.
It's only the state respondents.
Yes,
Only the state respondents are there. Yes, what is the matter about?
The matter, I have a 4-wheeler that is plying on the road as a taxi. But all tax has been paid according to the imposed by the authority concerned. Suddenly, additional tax rupees 48,000 has been imposed against me. And tell if you do not pay that amount, we do not supply any copy on in what manner that additional tax has been imposed that has not be furnished. But against that, petitioner came before your lordship. But the question is 48,000, more than 48,000. This is the annexer P6. The last annexer, page. Page 26.
Yes.
The 48,663. In what manner that additional tax has been imposed, that has not been supplied anything, my lord?
I have received a detailed report in this regard.
Not a copy, then?
It appears from the second paragraph, your lordship, please. আমাকে একটা কপি দিন।
That time estimate amount of tax and tax, additional tax, special tax, and TW tax was decreased up to 17 by receipt number such and such. In the tax receipt number such and such, the tax was deposited without additional tax and special tax, which was applicable for all the condition label. Hence, the present amount of tax, the additional tax and special tax are calculated from 20th February 2017 due to the non-payment of the same. These amounts were dues since 2017.
Yes.
I have given also handed over the copy to him.
But I given exception against this, my lord.
Please annex relevant documents showing
Patel.
that you have paid taxes for that period.
Yes, yes.
Because the authority says you have not paid the additional taxes for the relevant period.
So I paid all taxes according to my client, my lord. That has been annexed
Tax
already.
and additional tax are two different headings, isn't it?
Very well. I
So please see that all the components have been met. The affidavit says the petitioner challenges imposition of additional tax of rupees 48663 upon him by the respondents. Stop. In the report submitted on behalf of the respondents, it is stated that the petitioner failed to pay additional taxes since 2017, for which such amount has been levied upon him.
Both additional taxes and special taxes. Both are used.
Additional taxes and
Additional taxes and special tax.
failed to pay additional taxes and special taxes since 2017.
the tax, additional tax, or special tax.
Please see the provisions. If there are provisions, you have to pay.
No, maybe I challenge that provision also.
Learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 7th February.
7th February. Get for it.
Ready.
Urgent, my lord. 330 matter, my lord. Urgency is that, my lord. I am the tenant, my lord, despite deposit of my lord. Rain before the rain control, that was not taken into consideration. My learned friend is here, my lord. If not possible today, then tomorrow you kindly upgrade it.
Wait, please wait. Next.
Well, in this matter, let a report story. In the last occasion on 20th December 2000, directed to submit the report because of replacement order was issued. I have I fulfill all the terms and conditions of replacement order, but till date, my lord, no offer letter was not granted.
Right. Learned
For date,
counsel
my
to
lord,
respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on
that's for date, my lord.
31st January.
Yes.
Next.
Civil motion 629.
May I please your lordship?
I think it's 628. There's
623 is there.
628 extension. 628.
Oh.
628.
28.
Extension of interim order.
Oh.
who's appearing for the petitioner.
I'm better appear, madam. 151.
Sir? Yes, sir.
Yes, sir. Rakesh Jaiswal. Rakesh Jaiswal. Number of 6. Item number 628. Yes. Paid for, my lord, extension of the order passed by this honorable court at the time of, my lord, admission of the motion. Order.
Service complete? Yeah.
Yes, yes.
Who is appearing? He signed up, but
Extension. Civil extension.
I will see, yeah, good. কেউ নেই তো ওই জন্য।
let it be extended till 31st January.
Till, my lord?
31st January. Affidavit of service filed by the petitioners is taken on. Paragraph heard by counsel for the petitioners. Paragraph, the interim order granted earlier is extended till 31st January 2024 or after further notice, comma, documents like that. Paragraph, the matter be placed before the regular bench. Is the urgent matter next one?
My lord, this is, my lord, this is top fixed, my lord, 629, my lord.
Tomorrow.
Well, this is for disposition, my lord. Only thing, my lord, my lord, I,
Not resolution, sir,
my lord,
not mine.
yes, my lord, I feel it very embarrassing, my lord. If your lordship kindly takes up from 3 p.m. at least. My lord, I know, my lord, I am at fault. It's our resolution, my lord.
Similar prayer, my lord, 6:30 and 31.
And we need to honor it, isn't it?
My lord, only thing, if your lordship kindly considers and takes up, my lord, from 3 p.m. At least the matters will be, it's a very urgent matter.
Happened to my group 7 matters of this court.
I can understand, my lord, but at least for one day, because, my lord, since the day, my lord, lordship was granted the determined, only one day lordship could able to take it, my lord. Thereafter, none of the dates since, my lord, 3:30 and resolution was also. I can understand, my lord. I can understand, my lord. If your lordship can take, because this is of our disposition, my lord.
mentioning the matter.
This is a, my lord, in fact, my lord, if your lordship so wishes, my lord, can take this up now, my lord, because this is a no caveat matter. There is no other side in this.
Understand, but then group 7 matters will suffer, isn't it?
Lordship can give, since
If
lordship,
possible, tomorrow at from 12 p.m. to before recess.
Today,
No, not before recess. 12 p.m. to before recess.
fast or impossible?
But few matters.
my lord, from 3 p.m. onwards.
One motions.
But tomorrow, my lord, at least from,
Let's sit with about 700 matters.
I can understand, my lord.
Consideration, my lord.
The lordship kindly considers, my lord.
কালকে group 7 matter কতগুলো আছে? Group 7.
কাল যদি পুরো কোর্ট হয় 3টে থেকে না 1.5 ঘন্টা।
2 p.m. से तो হবে না 12টা থেকে হতে পারে 2 p.m. আবার কি আবার
12, 13, group 7 matters.
But 3 p.m. lordship, my lord. From 3 p.m. কেন?
একটু আসে।
জজ সাহেব একদম টাইমেই ডাকেন, আমরাই আজ করতে পারি না, মাম।
3:30 এসে গেলে তখন কি হবে
3:30 because because it is
yes.
recorded at 3:30 or after completion of group 7, whichever is earlier.
Yes, yes,
Recorded.
yes, yes, yes.
If I
That is
complete
recorded.
Yes, yes,
time,
yes.
take up these matters.
I know, my lord, lordship is always there, my lord. It's up. My lord, this is, my lord,
It is our,
your lordship, my
it
lord.
is our ill-fate, my lord. Tomorrow,
ill-fate.
tomorrow, if my lord, take only for tomorrow, my lord.
On,
Only for tomorrow, for from 12 p.m. to before recess.
or from 3 p.m. onwards, if your lordship for tomorrow only, my lord. Only for tomorrow only, if your lordship kindly takes up at 3 p.m. my lord. From 3 p.m. onwards.
31 and 32 is fixed for tomorrow at 4:30, my lord.
What is 6 at 3:30?
My lord, the arbitration against which section 631 and 632 has been referred, my lord.
Yes.
That arbitration is fixed at 4:30 tomorrow. That is the urgency, my lord.
I'll be unjust to the group 7 matters. This is not possible.
My lord, some kind of consideration for a
Oh.
day only.
3:30, let me see if I can finish group 7 matters. Before that, I'll take up.
Before extension of interim order.
Come back tomorrow.
Malad, before
Extension of interim order.
My lord,
My lord, before rising, my lord, 609, my lord, group 7 matter, my lord, I could not reach, my lord, Mr. Devroy, my lord, lordship kindly take it only not today, my lord, my Devroy.
609. Not today.
my lord,
Not today.
My lord, Devroy.
Department কে ডেকেছেন? আপনি আছেন department কে ডাকুন।
My lord, under compelling circumstances.
I'll speak to the department in my chamber and I'll let you know.
very well. My lord, yeah.
Under compelling circumstances, I am bringing one matter for the lordship's knowledge. Item number 66 of today's list under the heading group 1. Matter is due to appear tomorrow. It has wrongly appeared today. So let it appear tomorrow. As because the other side is state of Assam. They are coming.
Order passed.
Yes, in the order that is.
Has any order been passed?
Item 66. It should appear tomorrow.
It will be called.
Yes, they are appearing.
My lord, may I be permitted to one matter, my lord? PO number 85/2023, it was mentioned on last Thursday, my lord.
Again, sir.
Allowed my mentioning, and matter has come in the court from court number 19. But tomorrow is the trial court date, my lord. Kindly keep the matter tomorrow, my lord.
The matter will be disposed of by the trial court tomorrow.
No, trial court tomorrow it is, but the revision application will be influxed, and that's why I'm.
Why will it become infructuous? Please explain, sir.
Because tomorrow is the trial court date, and
for what?
Date for it is a probate matter, and that the evidence is going on. And
Evidence
that's
will again go on even after on subsequent dates. So don't worry, it will be taken up.
Great.